All right, we are all set up. Happy Friday, everyone. I'm all set up. There. Happy Friday, everyone. We have a final plea calendar this morning and 2 pleas from yesterday. And then I think this afternoon, we've got 1 federal inmate plea. I think that's set for 1 o'clock. Is that Wood, Rios? Wood. All right, great. I don't actually have his case number. I have his federal case number. We don't need it now, but
I'll get it to you.
We'll need it at some point. Okay, let's start with the final plea calendar just to see who's here. And I learned through Ms. Nelson that we had a couple arrests recently, unfortunately. So some folks will maybe be patching in via Zoom from the jail if we can make that happen. Marquise Sinkfield. Ms. Smith, have you had any contact with Ms. Taylor?
I have not.
All right. Well, we will give him a little while to get here. How about Duranta Jones?
Judge, I expect him, so I'm gonna reach out.
Okay, we'll hold off on that. Angela Williams, I think, was our recently arrested.
He was with the Department of Corrections and then was brought here, I believe, last week. So we're gonna zoom him in.
Got it. It's not recent arrest, it was production order.
Correct.
We just didn't get him over here today. I'm sorry. Okay. In custody. How about Antonio Burden? There's Mr. Burden. Good morning.
Judge, if we could come back to this one, I need to speak with the state.
Okay, and I should have said this, I just didn't see a lot of folks out here. So what final plea is the last day for you to enter a plea, if you're inclined to enter a plea in your case, where you can withdraw that plea if the sentence you get is different from what your lawyer asked for. After today, you can always enter a plea, you just don't have the right to withdraw that plea if the sentence you receive isn't what you asked for. And for every case we're talking about today, except for Duranta Jones, you are on the January 7th trial calendar. So if you don't resolve things today, for sure you'll be back in court on January 7th. So we can talk about getting ready for trial. So Mr. Burden, Ms. Wood's going to talk with you, and then she'll talk more with Ms. Smith, and we'll figure out if we're doing something with your case today. Martavius Kemp, I think he is the other one who is now in custody.
Yes, I think we'll be able to resolve the case today. I just need to talk to Mr. Kemp. He was accepted to the whole house.
Okay, and is he one where it was a surprise that he's in custody, or
No,
we just didn't get him here?
Yes.
Okay, got it. All right, how about Nevada Twitchell?
Your Honor, David Howell, appearing on behalf of JI Conflict. Mr. Twitchell's here. We would like to have a bond modification hearing.
Okay, that's on the calendar for us to talk about that. Ms. Smith, this is Mr. Abadi's case. Will he be here soon? Okay, why don't you check with him? So we'll do both things, Mr. Howell. We'll do bond modification, but we'll also talk about whatever the state's offer is. Mr. Twitchell can say, I'm not interested in that, or I am, and we'll take it from there. All right, thank you for being here for Mr. Act. Aaron Michael Pendleton.
Yes. Morning, Judge. Tim Cook and Mr. Pendleton. We're both on Zoom. And Ms. Williams has got the case for the state. We are in active negotiations this past couple of days, and this morning we don't have an offer yet, but we're working on it.
Okay, well, we'll get all that on the record in a second. I'm just sort of taking attendance, but it sounds like we've got everyone for this case.
Yes.
How you feeling a little better today, Ms. Williams?
Not really, but I'm keeping my germs to myself, so
Good.
we're gonna work with that.
All right, excellent. I mean, not excellent that you're not feeling better, but excellent that you're where you are. Hey, how about Charlie Daniels? Charlie Daniels is here, as is his lawyer in person this time. How are you?
Well, Judge.
Something funky happened with the live stream that we do, and for about 2 hours, I don't remember if it was yesterday or the day before when you had appeared, your face was the only thing people on the live stream, they could hear what was going on in court, but it was you in your car. Yep. So I think that was a lot for the live stream audience.
I mean, a little of me goes a long way.
Yeah, it did. It went a very long way. Final plea date for Charlie Daniels. Have you had a chance to speak with Ms. Smith? You need to do that this morning?
Judge, well, you want to do this down, Judge, we just got an offer last night, and I'm not saying we're not gonna take it, it's just we got so recently, there hasn't been too much time. I understand this final plan, I'm not saying the case won't resolve, it's just.
Okay.
It's got to the point where we're starting to work on it.
We'll get it on the record in a second. You're here and your client is here, which is great. All right. And then finally, we have Ms. Woodson, who I see her name online. Ms. Rios.
Yes, Your Honor. That we sent the order, I believe, for the Ms. Willingham did for the judicial hold.
Yeah, I thought I had done that, but it's not in the docket. The name seemed familiar, so I looked it up this morning and it wasn't showing in the docket. But this was this a DA adult diversion, or this was a one that the lawyers had?
The TI situation.
Yeah, okay. I'm pretty sure Ms. Willingham got that to me. And I thought it had been e-filed. But that's the plan. That hasn't changed?
Yes, sir.
Okay. Ms. Woodson, can you hear me?
Good morning. Yes, sir. I can hear you.
Good morning. How are you doing?
I'm doing pretty good.
Good. You do not need to stick around. Your lawyer has negotiated a diversionary program for you. You know the things you need to take care of over the next 6 or 9 months, whatever it is. And as long as you're doing that, we don't need to worry about your situation. Do you have any questions about that?
I just want to, no, I guess I'm good. I'll just contact her after court's over.
You know how to reach her?
Yes.
Great. Then why don't you reach out to Ms. Rios, and you are good to go for today.
All right. Thank you. Have a great day.
You too. Check the docket again.
Judge, I sent you a message on Teams.
Oh, Teams it is. Okay, let's see. Got it. Okay, we're squared away with Ms. Woodson. And then we should be able to take pleas today with Ms. Mann.
We are still talking.
Oh.
So she's not logged on yet because I need her to have her phone from each other.
Okay, and then Ms. Dawson. Hey, Ms. Dawson, we're waiting on Mr. Richardson again. Okay. You may want to reach out to him just to let him know you're here. I think, he told us he was in another judge's courtroom. We're good. Okay. All right. Then let's take care of some of these final pleas. Marquise Sinkfield, you show up? You are here. What do you know about Ms. Taylor? Have you reached out to her?
Yeah. Oh, you should be on the way to get another page.
Okay.
Yeah, so.
All right, then you should sit tight, and when she gets here, we'll talk about your case. Ms. Wood, you're going to check on Duranta Jones. And we're waiting to get Mr. Williams on. You want to talk more with Mr. Burden. Kent, we're hoping to get on. So, Mr. Abadi, you're here. Are you ready to talk about Mr. Twitchell's case? All right. So, Mr. Howell, if you and Mr. Twitchell will come to council table, and I need one of you, Ms. Rios or Ms. Wood, if you could make a little, we have 2 people coming to defense council table. All right, let's get on the record in this case. Good morning, Ms. Rivers. You good to go?
Good morning, yes, I am.
Great. This is 25 SC 002-653, State versus Twitchell. Mr. Twitchell is charged with homicide by vehicle in the first degree, feticide by vehicle in the first degree, and a couple of other driving offenses. He's out on bond. He wants to have his bond modified, but we also have to talk about final plea. Mr. Howell is here on behalf of Mr. Apt, but I'm going to assume you know a whole bunch about the case because we need to cover a couple topics like how's discovery going? And hopefully Mr. Apt would have let you know if he was missing your client's statement to the police or accident reconstruction or anything like that. Have you heard?
I've discussed with people in the office and I'm aware of kind of where we're at.
Great. And where are we at with discovery?
I believe we have everything we need. However, we have engaged the services of a accident reconstruction expert. So we will need a little time to flesh that out prior if we were to reject the offer and move to trial.
Okay, so trial is early January. You have time between now and then to get things done. Of course, the state would need to be given time to react or respond if they chose to, given that really this reciprocal discovery was already due. Do you have a forecast, Mr. Howell, for how long the accident reconstruction work will take?
I don't, I would say
Best guess.
probably 45 days.
Okay, maybe through the end of the year.
Correct.
All right. I'm not familiar at all with what is alleged to have happened here. Is it your sense, Mr. Abadi, that there's anything that needs to be reconstructed or someone was going 100 miles an hour and hit a tree? And you can have an expert, but the state wouldn't see a need to rebut that or respond to it.
It's probably the latter.
Okay. I'm not holding you to that, but you're not thinking that upon receipt of the defense expert's report, you're going to then need 90 days to come up with something from the state side?
No, Your Honor.
Okay. All right. Then, Mr. Howell, what I'm going to do is keep the trial date that we've got, and you and Mr. Apt can lean on the reconstruction expert to see if he or she can get things done promptly. And then I guess on the 7th, when I'm calling the trial calendar, we can talk more about where things are or where things aren't. All right? So you're good with discovery. You may have some reciprocal discovery flowing from this reconstruction if it's something you choose to use. Obviously, if you read it and say, let's hide this under a bush, it's not disclosable because it's not anything you're using. Okay. All right. Mr. Abadi, what is the state's recommendation if Mr. Twitchell wanted to resolve his case today?
I was talking to the defense counsel and I said we could obviously go non-negotiated, but the state's recommendation would be a global sentence of 15 years to serve 10.
Okay. And that's something you had communicated to Mr. Apt or Mr. Howell before today, or is this the first time Mr. Twitchell would have been hearing 15 serve 10?
Me and Mr. Apt had talked kind of generally.
Mhm.
I don't know if he communicated that to his client, but I spoke to Mr. Howell earlier today, but I didn't anticipate that they would be accepting doing a plea today.
Okay. Mr. Howell, have you and Mr. Twitchell been able to discuss what the state's recommendation would be? There's not a mandatory minimum here. Just Mr. Abadi's letting you know if Mr. Twitchell said, let's resolve this today with a plea, that's what the state would be recommending.
If I could have a few minutes just to go over it with him in the hallway.
Sure.
You know.
No, I'll let you do that. Mr. Twitchell, let me explain what's happening today. You're not committed to doing anything in particular. But if today you choose not to enter a plea, then the only thing that's changing is that when you do decide to enter a plea, if you do, I should say it that way, if you do decide to enter a plea, you wouldn't be able to withdraw that plea if the sentence I imposed was different from what your lawyer advocated for. Let's use some facts. If we did it today and Mr. Abate recommends 15 to serve 10, and Mr. Howell gets up and says, you know what, it should be 10 years to serve 5. I'm making that up. He might say something different, but 10 serve 5. And I were to give you anything more than 5 years to serve, you'd be able to say, no, thank you. I was willing to do 5, but not 8. And so I want to withdraw my plea. No questions asked. A jury would never hear about the fact that you thought about pleading guilty or anything like that. Tomorrow or next week or January 7th, when I'll see you again, you can enter a plea. You always can do that. And Mr. Apt or Mr. Howell or both of them can be here and they're going to advocate for whatever they think is a reasonable sentence on your behalf. The state may still be coming with 15 to serve 10. They, because they've done more work, may be saying, no, it should be 15 to serve. They're going to argue for whatever they argue for. The difference is on that day, if you're saying, yes, I'm entering a plea now, I will listen carefully to both sides. If Mr. Apt or Mr. Howell is saying it should be 3 years to serve and no more, and I say it's going to be 8 years to serve, you're unhappy with that, but you don't get a withdraw. It's like if you go to trial. If you go to trial, you don't get to say no to the sentence. If a jury finds you guilty, I have to sentence you. And if I sentence you to 8 years, that's your sentence. And you can appeal it, but you don't get to say no. You get to say, maybe there was a legal error and my lawyers will challenge that in the Court of Appeals. So the big change is just that ability to withdraw your plea, not your ability to plead or your right to go to trial. Does that make sense?
Yes, I understand.
Okay. I'm going to let you and Mr. Howell talk about what the state's offer is and if you're even in a position to be advocating for something different at this point. Before that, though, let's talk about bond modification so that when Mr. Twitchell comes back on the record, we just have that little piece of plea or no plea today. So, Mr. Howell, as I understand it, Mr. Twitchell, one of the conditions of his bond is that he is at home 24 hours a day. It's basically house arrest, with the exception, obviously, of a medical emergency or coming to court. That means he could work, but if he works, it's some kind of online job. He doesn't go to the grocery store. He doesn't do whatever. He is at home all the time. And this motion is asking that it be modified so that he could leave home, again, for medical emergencies or court, but also for work. Is that a fair summary?
That's a fair summary, but also, we would also ask for school. My client has been in school, working on an advanced degree. He would like to be able to go to Kennesaw State, where it would be his next school that he would be going to, where he would like to pursue an engineering degree. I believe that's appropriate in this case. As the court may be aware, Mr. Twitchell doesn't have a prior felony, no real criminal history. This was just a random incident that occurred, an accident, truly an accident. You know, I don't think the court has to be concerned with, you know, risk of intimidating witnesses, risk to reoffend, and the amount of bond certainly is enough to secure Mr. Twitchell's attendance at trial.
How would Mr. Twitchell get around? I don't know what his licensure status is. I've been surprised. Yesterday, I took some pleas in cases that involved running from the police at 150 miles an hour, and a guy still has a driver's license.
You know, he doesn't need, I spoke with him about that. He doesn't have to drive. You know, there's, in this day and age, there's plenty of ways that you can get around.
You bet.
So if, you know, I think it would be okay to allow him to drive, you know. I don't think that there's a requirement for the other two really to be implemented.
Okay. What would work be? Because you said work and school.
His old job at Atlas and Buckhead.
What is Atlas?
It's a fine dining restaurant.
Oh, that's why I haven't heard of it. It's fancy. Okay. Like cloth napkins?
Yeah.
Okay. What do you do at Atlas Restaurant?
I was a line cook there.
Okay. And would you be able to work and go to school, or is it an either or just scheduling wise?
I can do both. I was gonna look to go back part-time. I just need to earn a little bit more money, help with living expenses, but all my classes as of now are asynchronous, so I can do them whenever.
Asynchronous, okay. Clearly you're gonna be an engineer. The, job would take you back. You have been in touch with Mr. Atlas?
Yes, yes, sir.
Okay.
I'm still, waiting to hear about details and I'm dependent on this, but they said they would have me back.
Okay. All right. Mr. Abadi, your thoughts about modifying bond in a way that would allow Mr. Twitchell to go to school and or work, and he wouldn't be driving himself. I'll just get that out there up front. If that was one of your concerns, Uber, Lyft, mom, dad, the Kennesaw State has this nice owl bus, depending on where he lives. So your thoughts?
I guess my thoughts, I would leave it in the discretion of the court. My only concern would be as it relates to work, that not be a real modification until there's some confirmation that he actually is going to work there and has the ability to go back to his prior job at Atlas.
Okay. Was there an earlier indictment? The docket starts with the bond, but not the bond order, the bond that he posted.
If you go to the jailing screen under jail manager, apparently there was a consent bond and it was filed under the warrant numbers.
Oh.
It's in the document section I can email it to the court.
That would be great if you would do that. So Mr. Twitchell, I will modify your bond after your lawyers get to me, and anything sent to me by your lawyer should also go to the prosecutor. They get to me something from the restaurant saying, here's when he'll be working. Not a handwritten note on a napkin, but it doesn't need to be a formal employment contract, but it's an email from the manager, whatever it is, saying, we're taking Mr. Twitchell back. It's going to be Tuesdays and Thursdays from whatever the hours are. And for school, I would need to see something from the school saying Mr. Twitchell is enrolled in these courses that meet at these times. Does that make sense?
Yes, sir.
You have an ankle monitor?
Sir.
You don't have an ankle monitor?
No, sir.
Oh, how do we know you're staying at home? Just because you're saying you're staying at home?
Yes,
Huh.
sir. I mean, I was in a wheelchair and in the hospital at the time.
So you weren't going to be going particularly far initially?
Yes, sir.
All right. To make this easier, we'll be modifying your bond in a variety of ways. And one of the ways is that you'll have an electronic monitor, county funded. You're not going to need to pay for that. But that will help ensure that work hours you're at work and school hours you're at school. And it's not, oh, look, it took him 4 hours to get to school. I'm sort of surprised there wasn't electronic monitoring, whether you're in a wheelchair or not, because it's kind of hard to enforce house arrest without something like that. But
Your Honor,
I didn't set the bond.
just a quick rebuttal to that, and then.
Rebuttal to your client getting what he asked for?
Well, no, with the ankle monitor, this is a single incident in a lifetime of, unassailable conduct. I'm not sure that, the ankle monitor, he's been on bond for the past, since 2024, I guess, without a monitor. There are ways to enforce house arrest, the state could go by his house, and if he's not there, then, he's obviously violating.
True. I could ask Mr. Abate to go by every Thursday at noon and see if he's there. I'm not going to do that. I'm not trying to make things more complicated for Mr. Twitchell. I'm surprised that his initial bond that had as a condition of house arrest he didn't have an ankle monitor then. And it's ugly, it's funny looking, people are gonna see it, they're gonna wonder what's going on, and you're gonna tell them, I have this tragic situation, I killed someone. You can tell them whatever you tell them, but if you want the degrees of freedom that you're asking for, to which I think you're entitled because it's work and it's not, hey, could I want to just go have a good time in Cancun. That's not what you get to do right now. And that's a burden, and you're presumed innocent until you plead guilty or a jury finds you guilty. But I need to make sure that something like this doesn't happen again. And this is one way to do that. So I'm all for you continuing your education and working to help defray those household costs you described. It just may work in a way where you got this little box on your ankle. They have these wrist ones that just look like some kind of Apple Watch thing. We, the county, can't afford them. So if it becomes a lifestyle concern, or I mean, literally like, I can't, the Atlas won't take me back because the customers are going to see there's a guy with ankle monitor on in the kitchen. I don't think they're going to see you in the kitchen. Then if he wants to self-fund it, they do have the agency that monitors for the county also has these wrist versions that are much more stylish. But they're also more expensive, and we only fund the ankle ones. So food for thought if it gets to that point. So I will look at what the bond, how it was structured. I'll do an order that modifies it, that allows for work and school, but I actually won't do any of that, nor impose an ankle monitor requirement until I get some of this verification from work or from school. But you've got the green light once I get that. Any other questions, Mr. Howell?
Nothing. It may come in, two different waves. There may be, work may come before school.
And I won't wait for both. And when I get one, we'll do a bond modification that says it's house arrest except for court, medical emergency, and work. But that way the monitoring company will know what your shift is. And so you being en route from home to Atlas and then being at Atlas for 6 hours on a Saturday won't cause red lights to go off in their office, because that's part of the known situation. Because they send emails to the state and to me when there's a perceived violation. And so if your work schedule was Monday, Wednesday, Friday, and Tuesday, you're heading down 75, then we get an email saying something was up. And it could be because you were on your way to Piedmont because you broke your arm, and then your lawyer can show us the medical, this and that. But if it's something different, then that's how we enforce the whole house arrest thing. Okay? Mr. Abadi, anything else on behalf of the state?
No, Your Honor.
You don't see any reason, other than we've got this variable of the defense expert, that this couldn't be ready to go for the January calendar. Okay. Mr. Howell, why don't you and Mr. Twitchell spend a little time talking about, is today a plea day, or do we move the case forward? All right. Mr. Cook and Mr. Pendleton, you ready to have a conversation?
Yes.
Great.
We are, Judge. Thank you.
Let's get everyone there. Excellent. Mr. Cook, well, first let's get on the record. This is 25 SC 002-761, State versus Pendleton. Mr. Pendleton and his lawyer are, well, actually everyone is appearing virtually. Mr. Cook, how is it looking to you on the discovery front? Any concerns?
No, I do not have any discovery concerns. It came about a month and a half ago, and it seems to have everything that we would have expected.
Okay. Is this a situation where you got a hard drive, or count one is uncommon here? And so I'm just curious if you got printouts, or what is there a digital component to it?
No, Judge. This is a I colloquially call this the fake underage person sting. This is not a actual young person or actual pictures or anything like that. This is just the evidence would be essentially meeting a undercover person.
Okay,
That's it.
but they communicated electronically in advance that led up to the meet?
Right. It just some digital typing correspondence on a website.
Got it. But you've got all that. You're not lacking whatever those.
That is my understanding, that I have everything that was discussed at the preliminary hearing and that I was expecting.
Okay, excellent. Ms. Williams, what is the state's offer at this point?
Your Honor, I believe that, and I'm trying to pull up Odyssey at this moment to find out exactly the terms of the last offer from the previous prosecutor, Ms. Clark.
That wouldn't be like in your file? That's in Odyssey?
Yes, Your Honor, we keep a lot of our items electronically now.
Okay, but in your part of Odyssey, like I'm looking in the docket now, there's nothing that says Ms. Clark offers 100 years to serve.
Oh, correct. It would be the district attorney side of Odyssey. Yes.
Got it. All right. Maybe
Do you have a
sometime.
better recollection?
Pardon me?
I can tell you that we were never communicated an offer. The case, to our understanding, Ms. Clark had the case for a couple of days. In between, I think she was taking over for who was it? Who was on trial? The supervisor, I'm just blanking on her name. I'll come back in a minute. But there was no offer. Discovery came after I requested someone send it to me in September, but no offer came. And Ms. Williams, you and I are the only, you're the only prosecutor I've had any meaningful discussions with in our couple of pretrials that we've conducted in court over the last couple of weeks. But
why don't we do this then? Because I don't, it's clear that you all need, if Ms. Williams actually can't even state what the offer is, because it was a predecessor and maybe it wasn't super clear and there hadn't been a lot of contact between that predecessor and Mr. Cook. I propose preserving Mr. Pendleton's final plea rights, keeping this on the trial calendar because there are no discovery issues. People need to get ready for trial in early January. But Mr. Pendleton will have the ability to, if he chooses, enter a plea on or before that trial calendar date and still be able to withdraw that plea if the sentence that I impose is more than what Mr. Cook asks for. So we just, all the rights you have today carry over to that trial calendar. Does that work for you, Mr. Cook?
Absolutely, Judge. We completely agree with that plan.
All right. Are you all right with that, Ms. Williams?
Yes, Your Honor. Thank you so much for your indulgence.
It's not indulgent. I think it's more efficient because it sounds like we need to go around and around some, and I don't want to put it on another final plea calendar. It's actually ready to go, but I do want to give both sides a chance to have some conversations about a non-trial resolution. Mr. Pendleton, do you have any questions about what we've been discussing?
No, sir.
Okay, well, stay in touch with Mr. Cook. He'll let you know what's going on. I will see you again in person, not on a screen, on January 7th for the call of the trial calendar, unless before that date, you've resolved this case, okay?
Yes, sir. Thank you.
All right.
Thank you, Judge.
You guys have a good weekend.
You too, Judge. I'm Ms. Williams.
Thank you. I'll talk to you soon, Mr. Cook.
Mr. Majeski, should we talk about Charlie Daniels? Why don't you two come on up to council table, please? All right, and your case is with Ms. Smith, so we've got everyone we need right here. So let's get on the record in 25 SC 003-256, State versus Daniels. Mr. Daniels and Mr. Majeski are here, as is Ms. Smith. Mr. Majeski, you let me know when I was just calling the calendar that People are still talking, but let me start with discovery. Do you have any concerns about discovery?
Just one concern, Judge. I think I have all the discovery the state has, probably. The only concern that I got is in the incident reports. It mentions the possibility of the existence of video footage from the alleged crime scene. Now, I didn't get that, but I also don't know if the state has it, because I don't know if law enforcement ever collected it.
Got it. This would be commercial surveillance, not body cam, but someone says, hey, there may have been a camera at a gas station.
Yeah, like a ring camera. That type of
Okay, got it. Ms. Smith, do you know if law enforcement ever did obtain the surveillance footage?
No, Your Honor, we don't have that information, but I can reach out again through my investigator to see if you can get that.
Okay.
If it exists, I'll ask her.
All right, so I'm clear. You don't have it for sure, because if you had it, then you'd hand it over. You're just not sure if law enforcement ever did get it.
Right.
And if they didn't, then it probably doesn't exist anymore, but it's just as accessible to defense counsel. But if they did get it, you will get it from law enforcement and get it to Mr. Majeski.
Yes, Your Honor.
Okay.
It's one of those deals where law enforcement, I'm sure you've seen this a million times, they'll talk to the alleged victim. The alleged victim will say, I got this evidence. They'll say, hey, get it to me.
Yeah.
It's one
And there's no follow-up.
Right.
I mean, there may have been follow-up, but they never got it, but you had, the paper trail ends.
You're right, yeah. Otherwise, the rest of the discovery the state's giving is actually impressively extensive.
Okay. Do you have any reason to think, Mr. Majeski, that the footage would be a deal maker or deal breaker? Because it would prove something up that your client is saying, there's no way it happened, but then look at the video. It's going exactly the way the victim said, or the reverse, that it would show that your client wasn't even there.
It would be one of those two things, Judge.
Okay, so it's important.
If it exists, Judge.
Right. Okay. Why don't we then not have a final plea discussion right now? Because if it is bad news for your client, then you have a little less leverage in the conversation. If it is great news for your client, we may not need to talk about a plea. But I don't want to take this off the January 7th track. So I will preserve Mr. Daniels' final plea rights. And as long as the state doesn't drop the video in your lap on January 6th, I think we'll be okay. In particular, if the answer is they never got it.
Ms. Smith doesn't do stuff like that.
I don't think she does either.
Yes, Judge, thank you. That's exactly the relief I was going to ask for this morning. Thank you.
Okay. So, Mr. Daniels, we're not going to work through, hey, do you want to accept this offer today or not? Because there is this, potentially this piece of video evidence that could be very helpful to your defense or helpful to the state's prosecution of you in the case. So Ms. Smith knows what her team needs to do. They'll confirm, yeah, the police got it, or no, they didn't. And if they didn't, Mr. Majeski can beat up on the officer verbally. If there's a trial, like, why wouldn't you follow this lead? But my guess is if it wasn't collected then, although if it's ring footage, who knows, it may still be out there, as opposed to one of these gas station cameras that records over itself every 14 days or something. But Ms. Smith will look into it, and there's ample time. It's almost 2 months before that trial date. You don't need to loop me in, just let Mr. Majeski know whatever the situation is. And we'll see everyone on the 7th. I encourage you both, please, if the way this plays out is, well, we don't want to go to trial, we need to work it out, don't wait till the 7th. If you then work something out, even if it's not negotiated, because you're at 2 and you're at 1, reach out to Ms. Nelson and say, could we get a date before the 7th? The 7th will just, you sat through these. It is a busy day, and you'll be here for a long portion of it before we could take that plea, as opposed to saying, well, how about if I come in on December 18th or something, and then it can be focused just on this. Mr. Daniels, do you have any questions about anything we talked about?
No, sir.
Okay. Any issues with your bond? No? Okay. All right. Mr. Majeski, anything else?
No, Judge, thank you.
Ms. Smith?
No, Your Honor.
All right. You'll figure out what's going on with that video?
I will.
All right. Thanks. You guys are good to go.
Thank you, Judge.
Thank you, sir.
Well, like you.
Mr. Howell, you guys don't even need to come all the way up if the answer is we're going to trial. I'll just make sure we get that in the record.
We're gonna reject it.
Okay. So Ms. Rivers, if we could go back on the record with position 7, ending in 2653. Mr. Howell, you had a chance to speak with Mr. Twitchell, and what you two have concluded is that you're saying no thanks to that offer, and you'd like the case to stay on the trial calendar. Good. Okay. Please, you or Mr. App keep Mr. Abate and Ms. Nelson posted about this expert work, and if you're foreseeing it interfering with that trial date. Okay. And then I'll be on the lookout for, I have a copy of the bond now. Thank you, Mr. Body. On the lookout for proof of employment, proof of what the school hours are.
Very good.
Okay?
Thank you.
That.
That concludes my business. Have you excused?
Yes, sir. Ms. Wood, did you have a chance to either track down Ms. Mann or speak with Mr. Burden?
So, yes, so.
You guys can have your table back.
So Miss Mann and I spoke actually this morning, like at 8 a.m.
Mhm.
And I know she's available because she has her phone and she's at work. So now I'm just trying to get her to answer so I can give her my most recent update from Ms. Williams.
Okay.
So I'll keep trying to do that. I have spoken with Mr. Burden. That'll just be some sort of final hearing, Judge.
Okay. Well, why don't we do that? Mr. Burden, can you come on up, please? And you can just come right next to the podium. Yeah, just come right next to where Ms. Wood's standing. Perfect. All right. So your position 5, we'll get on the record in your case, 25 SC 002-362. It's State versus Antonio Burden, who is here with Ms. Wood, and Ms. Smith is the prosecutor. Ms. Wood, do you feel like you've got, all the discovery in the case?
No,
No. Okay. What are you missing?
I don't know, Judge, because I just received the discovery link, which appears to be 3 zip folders
Oh,
about 15 minutes ago.
so you could have all of it, but you wouldn't know because you just got it.
Anyone's guess.
Okay. Because I was going to ask about Crime Lab, but I can ask Ms. Smith about that. So you need some time to go through that. Should we bump Mr. Burden to the next trial cycle and have another final plea? Do you want to keep him on the January 7th, but make that his final plea date? What is your preference?
Keep him on the January 7th trial date.
Okay, so we don't need to talk about final plea right now. Mr. Burden, you're going to preserve your final plea rights. Ms. Wood's not in a position to give you meaningful advice about whether the state's offer is a good one or a bad one. She needs to digest the discovery and also see, is there something in there that is suppressible? I'm making this up, but maybe the police come up and you're like, hey, these drugs are mine, these drugs aren't mine. And they didn't Mirandize you or something like that. And so she might try to get your statement thrown out. But she needs to see, did you make a statement? How was it obtained? All those kinds of things. Your lawyer is not late in doing that. She just got the discovery. So we had a transition in here, one prosecutor replacing another. And so there's a little catch up going on. But Ms. Wood is telling me that over the next month and 3/4, she'll have more than enough time to look at your discovery, talk to you about it. Let me know if there are any motions. If there are motions, then we probably will delay your trial date. But otherwise, we'll keep you headed towards that January 7th date. Does that make sense? Any questions? You can talk with Ms. Wood.
Okay.
She know how to reach you?
Yes, Judge.
Okay. Ms. Smith, talk to me a little bit about discovery. Thank you for serving it an hour ago or whatever happened.
No problem. When Ms. Wood told me that they did not have discovery, I sent that over immediately, but that is all that we have at this moment. We have GBI labs, everything that the state has, she now has. Anything that she doesn't have, when she reaches out, we'll try to get that if there's anything that's missing. But
Okay.
as far as discovery, that's fine.
Okay, and your review of what was in your collection of discovery does include crime lab reports. So we're not waiting on the GBI to say, I don't know what kind of drugs it was, but was it meth, not meth? How much did it weigh? That's already in there.
Yes.
Great. Okay. All right. Then that's just a fun reading project for Ms. Wood, and then she'll let you know what's going on. Anything else, Ms. Wood, on behalf of Mr. Burden?
No, Your Honor, thank you.
All right. So Mr. Burden, we'll probably see you on the 7th. Might see you before then if there's a motion that Ms. Wood wants to argue. But you just need to stay in touch with her. All right. You're good to go. All right.
Morning.
Morning, Ms. Alexander.
Morning, Judge.
Who do you have for us?
I have Mr. Kemp right now. We are currently waiting for, we need 1 North, I think I told him booth 4 for Mr. Williams.
1 North, booth 4 for Williams. And how about Kemp?
He's right here on South Annex.
South Annex. All right. Excellent. Well, we'll do South Annex now. Ms. Rios, you ready to talk about Mr. Kemp?
Yes, we should have a plea, if I could just be a breakout room so I can just tell him the
Details?
Yeah.
All right. Let's see what we can do here. I'm not understanding why. Hey, Mr. Kemp, can you hear me?
I only have one case.
Yes.
Hey, I'm Judge McBurney, and Ms. Rios needs to talk with you for a minute. So are you logging on, Ms. Rios?
I'm online.
Okay, I'm gonna put you virtually, Mr. Kemp, into a little breakout room so that you and Ms. Rios can speak privately. She just needs to give you a quick update, but it sounds like she and you are gonna be able to resolve the case today, okay?
Okay, thank you.
All right. Let me see what I can do here. It worked. And then I need to pull up 1 North, booth 4. Let's try again.
Okay, is he?
Yeah, he finished eating just about, he doesn't eat on 6.
Is there any probations anywhere?
Yeah, he's still.
This kid, 23, is it 23 SC?
It's a 24.
Okay, got it. How many years, how much time left over this?
Just over a year.
Got it, okay.
Or shall just murdered. Yeah, see that really clear.
Thank you.
Yeah, that's very. Right. Okay. Right. Yeah, yeah. You got it. Judge, can I be excused?
Sure can. Have a good weekend. So I was able to connect booth 5. I can't connect 4. But I also don't see the Ms. Anderson on anymore. Ms. Taylor's on. I don't think Mr. Williams can hear us. That looks pretty sealed up. Ms. Nelson, if you could, let's see if there's anything in there. Try to reach out to the sheriff's folks.
Yes, I just sent them a message. Let's see if I can figure
Great.
out what's going on.
Okay, because booth 5, we're good. I can't get booth 4 to connect. All right. In the meantime, Ms. Taylor is here. Good morning, Ms. Taylor.
Good morning, Judge. I still love y'all. I'm just stuck at DeKalb Superior Court this morning.
The love seeps through the screen. I'm glad you hopped on. I appreciate that. Let's get Mr. Sinkfield to come on up to the podium so you can see him and we can all hear each other. All right, there he is. There's your lawyer. So Ms. Taylor, Mr. Sinkfield actually has 2 cases.
Yes.
The newer indictment has already had final plea and is on our January 7th trial calendar. This case, which is an older indictment, I don't know which conduct is older, but older indictment, it just hadn't caught up with the other one. So today is the final plea for this case, but it's destined for the same trial calendar. So if we don't resolve this case today, both will be ready to go on that January 7th date. Are you okay with discovery in this case, Ms. Taylor?
Judge, I believe I am. I do want to talk with the state. I haven't, and that I'm not saying that it's their fault that I have not been able to reach them. But I believe we can resolve both of these cases, Judge, short of a trial. I would just ask the court to keep the final plea open. And I will get with the state to make sure that I have all the discovery but for some plea discussions.
Okay, well, a couple.
I have some mitigation that I do want to give to the state.
Mitigation, you said?
Yes.
Okay, so a couple things. One, we have a newly assigned attorney to this courtroom. So that may be one reason why you weren't able to reach someone associated with your cases. Ms. Davis, who had the cases, is in a different courtroom now, and Ms. Smith is the line or trial ADA who's got both of Mr. Sinkfield's cases here. Ms. Smith, do you have a way to reach Ms. Taylor? I want to make sure you two can connect.
I believe I have her email address.
Okay. All right. Ms. Taylor, is phone or email a better way for Ms. Smith to start reaching out to you?
Reach out to me both ways, Judge. If she can put her information in the chat, I certainly can. She's got my email. And she can put her email and phone in the chat. I will make sure I put my cell phone in the chat. So either way, and both ways is fine.
Got it. Well, I'll have her do that. So you guys.
Because I don't believe I have her contact information, Judge. So if she can put that in the chat, that'll be fine.
Okay, she's working on that, so you'll get that. And what we'll do is move this case, the older indictment, to the same trial calendar as the newer indictment. That's January 7th. So at the latest, Mr. Sinkfield, you'll be back here on January 7th. You'll get notice. Did you get something in the mail telling you to be here today?
Yes, sir.
Good. Same address we'll use. It'll tell you to be here on January 7th for both cases. That's the call of the trial calendar. Whether you go to trial or not is more up to you and Ms. Taylor. Her review of your cases is that it should work out with a plea, but you and Ms. Taylor will need to talk about that more. And we'll sort it out either on the 7th or ideally even before then if she and Ms. Smith are able to do that. Do you have any questions?
No, sir.
Ms. Smith, any questions or updates from the state? All right, Ms. Taylor, anything else on behalf of Mr. Sinkfield?
Nothing else from us, Judge. Thank you.
Okay. Ms. Taylor, you had a different client who said that he or someone who wanted to be your client who said that he was going to need to get a different lawyer because you had told him, I don't remember his name, so don't ask. You had told him you actually weren't taking new clients and you were gradually closing down your business. Is that true?
Well, just yes, sort of, yes.
Okay. Well, I won't press you on it now. I just was sad to hear that. I mean, we all reach a point where we're going to go do other things and enjoy time away from the office. I just wasn't sure if that was your polite way of saying you're not paying me what you need to pay me, or if in fact you were winding things down.
I'm winding things down, Judge. This November 16th makes 35 years for me, so it's time to wind.
It is. That's amazing. They need to write a book or do a documentary about you. All right. But you will see it through for Mr. Sinkfield. You'll be with us at least through the January trial calendar.
I will, Judge. Thank you.
All right. Well, good.
All right.
You're good to go. You can go back to DeKalb work.
All right. I'm going to put my stuff in the chat and then I'll.
Oh, yeah. Make sure you get that info exchanged. Mr. Sinkfield, you good? All right. You're good to go. Oh, South Annex is back. Maybe Ms. Rios will pop in here and we can do that plea. Well, we've got one north booth 3, so we've got booth 3 and booth 5. Ms. Simpson, you mind checking, see if Ms. Rios is coming out here? Thanks. Okay. Ms. Dawson, did you confirm Mr. Richardson's actually in the building? Okay, he's just in that other courtroom?
He's gonna be first after Judge Scott, I'll take his attendance.
Okay. You have any idea where Ms. Rios is?
No, Drew.
We checked
Oh.
because Mr. Kemp is back and I just got the terms of the plea. There she is. Oh. Are you Mr. Williams?
Yes.
Good morning.
Good morning, sir. Good morning. Good morning.
We're not going to leapfrog Mr. Kemp, but what are we doing with Mr. Williams today?
I just need to convey an offer to him, so do you want me to hop on Zoom to do a breakout session?
That'd be great. You guys can swap. You can have the jury room now. So Mr. Williams, Ms. Wood is going to get in onto Zoom. I'm going to move the two of you into a breakout room and you guys are going to talk about your situation, okay?
Okay.
All right. In the meantime, Ms. Rios, are you ready to go with Mr. Kemp?
Yes, Your Honor.
All right. Then let's get on the record with position 6, which is 25 SC 002 536, State versus Martavius Kemp. Mr. Kemp is appearing from the South Annex. His lawyer, Ms. Rios, is here in court. I'm gonna get her on the screen so you can see her. Mr. Kemp, we'll get our prosecutor on the screen. And we can move that. And we'll get Mr. Williams off the screen in a minute. I just need to, once Ms. Wood gets on, we'll get them in a breakout room. Mr. Kemp, I need the folks at the South Annex to unmute you. There we go. Mr. Kemp, you have a right to be here in court rather than at the South Annex, but you can waive that right so we can go forward with your plea in this setting. Are you comfortable doing that?
Yes, sir.
Okay. You also have a right to have Ms. Rios right next to you so you can ask her questions if things come up. I'm going to let you take a break anytime you want to speak with her privately. We'll get you right back into one of those breakout rooms. Are you okay proceeding with Ms. Rios here in court?
Yes, Your Honor.
Okay, that's what we're going to do. Ms. Smith is going to put you under oath in just a moment, ask you questions about your case and your rights. I need you to answer those truthfully and to let me know if at any point you have questions of your own, okay?
Your Honor.
All right, Ms. Smith?
Yes, Your Honor, thank you. Mr. Kemp, can you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Martavius Demond Kemp.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 38 and I went to the 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
And do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive the formal reading of this indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Kemp, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No, ma'am.
Counsel, are you aware of any outstanding warrants?
No.
Do you understand that you are entering a guilty plea to the following offenses? For count 1, robbery by intimidation, and count 2, simple battery against a person who is 65 years or older or who is pregnant at the time of the offense?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years probation?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing?
Yes, ma'am.
Okay. Are you currently on probation?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you also understand that by pleading guilty here today, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No, ma'am.
And as to indictment number 25 SC 002536, how do you plead to count 1, robbery by intimidation, and count 2, simple battery against a person who is 65 years or older or who is pregnant at the time of the offense?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
Yes, ma'am.
Do you also understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. This discretionary appeal procedure is outlined in OCGA 5635 and must be completed within 30 days of today.
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay, thank you. Your Honor, if this case were to proceed to trial, the state would show that on August 22nd, 2024, at approximately 12:43, Zone 5 Officer Brooks responded to a report of a robbery at 232 Forsyth Street, Southwest Atlanta, Georgia, 30303 in Fulton County. And this was at a Greyhound bus station. The victim, Mr. Jesse Chapman, stated that he was robbed by approximately 4 suspects while attempting to purchase a hot dog. Mr. Chapman reported that after he pulled out his wallet to pay for his hot dog, the suspects dragged him to the ground, took his wallet, which contained $500, his military ID card, driver's license, and other personal items. The victim also reported that his cane was taken during the incident. He further indicated that the incident happened very quickly and that he was traveling to Cleveland, Ohio, and all of his essential items were in his wallet that was stolen. During the investigation of the case, this was on August 25th, 2024, security footage from the Greyhound bus station was reviewed, and that footage confirmed what the victim had told the officers the day before. It also showed that when the victim was exiting the side door of a Greyhound bus station lobby, making a right turn, he was walking with his cane when an unknown female wearing a green sweater and light gray jogging pants was observed approaching Mr. Chapman from the direction of a black sedan, where the defendant, in this case, Montravius Kemp, was standing. The female then walked alongside Mr. Chapman toward the area where the houses were being sold during near another car. Approximately at 12:47, that's when the footage showed Montravius Kemp, who was wearing a red sweater, dark jeans, and a red and white hat turned backwards, and he was observed standing behind the victim in this case. Mr. Kemp then grabbed the back of Mr. Chapman's short and dragged him to the ground. After Mr. Chapman fell, Mr. Kemp then and another unknown male suspect were seen going through Mr. Chapman's pockets and taking his belongings. Kemp then fled the scene on foot, heading east behind the Greyhound bus station, while the other suspects drove away in a black Acura. Following this investigation, the officers then had a warrant out or drafted a warrant for Mr. Kemp's arrest. He was then found and placed under arrest under the charges we have here before us. And those are the facts of the case, Your Honor. Regarding the negotiated plea between the state and defense, we've agreed to for count 1, 7 years probation, and for count 2, 12 months probation to run concurrent to count 1. The special conditions of probation would be for Mr. Kemp to enter and successfully complete Hope House, to stay away from the victim, to complete 60 community service hours, and for him to have gainful employment and also receive his GED. And that is all from the state, Your Honor.
All right. Thank you. Good morning, Ms. Jackson. Do you have criminal history information on Mr. Kemp?
Good morning, Your Honor. There are 44 cycles. The last arrest was November the 6th, 2024. And with the city, was it Fulton County, for conspiracy to commit a felony. That charge was dismissed on December the 2nd, 2024. He does appear to be on probation. That case number is 24 SC 005806 for possession of a firearm by a convicted felon. That disposition date was April the 21st, 2025, and the term is for 10 years. He does appear to have an additional open probation case. The case number is 23 SC 191360 for possession of Schedule 1 controlled substance. Has the same disposition date of April the 21st, 2025, and the term is for 5 years. He does appear to have prior felony convictions, one in 2022 for aggravated stalking and terroristic threats and acts, one in 2013 for possession of cocaine, an additional one in 2013 out of DeKalb County for possession of a firearm by a convicted felon, one in 2011 for possession of cocaine with the intent to distribute, and one in 2008 for possession of controlled substance with the intent to distribute, and one in 2005 out of Clayton County for possession of controlled substance. And there are misdemeanor convictions if you would like to hear those as well, Your Honor.
No, I appreciate what you've shared. That is sufficient.
Sir.
Is he, did he already have a probation revocation hearing?
Yes.
Okay, so we don't need to handle that.
Well, no, let me back that up.
There wouldn't be one because this conduct predates those convictions. So this plea today shouldn't yield any revocation issues.
So the disposition date is this year.
Yeah.
Awesome.
That's what I was listening for, because one of the indictments is old, it's from 23, but they weren't resolved until this year. So, Ms. Rios, tell me about Mr. Kemp, and I'm looking at the letter from Caring Works, which is Hope House, which says we have not accepted him.
Sometimes those letters are confusing.
It just,
For something, because he definitely was accepted, because Ms. Ross told me he was, but sometimes it looks like, was it checked? Let me look at the letter.
oh, I see. Yes, it says we've accepted. It is very confusing.
Yeah, I've told them about these letters.
Got it. But the one that's checked, it's sort of subtle that it's checked. He's on a waiting list until a bed is available.
Yes, so we would have to just.
Got it. So he's in and then he'll sit tight until there's a bed. Ah, okay.
He is 38 years old. Prior to being arrested, he was working for Big Daddy's Kitchen. He is a cook. That is what he likes to do. He actually wants to go to culinary school. Unfortunately, his drug addiction and housing situation has prevented him from accomplishing his goals. So I'm hoping that the Hope House program helps him with that and gets him on track. He has one child who's 10 years old, and he wants to be a part of that child's life and do better. So I'm hoping with this resolution, he will be able to be a good father and kick the drug addiction. We did try to reach out to drug court, but they did not accept him.
Okay, that answers one of my questions. Thank you. Mr. Kemp, anything you want to add to what Ms. Rios said?
No, Your Honor.
How long had you worked at Big Daddy's?
2 years.
Okay, were you working at Big Daddy's when this situation at the bus station happened?
Yes. Well,
pardon me?
No.
No what?
I wasn't working.
How come? I mean, if you say 2 years, 2 years would include this time, August of last year.
I know. I had done quit because of my addiction.
Okay, you did work for Big Daddy's for a couple of years, but by August of last year, you had quit. You either weren't reliable because of the addiction, or you just said, working's not for me, I need to get high.
My grandmother died.
I'm sorry.
My grandmother had died August the 25th.
Okay, and then you relapsed.
Yes.
Okay. Well, August the 25th is after this incident, but maybe she wasn't well?
Died the 25th.
Okay. Tell me what drug or drugs you struggle with the most.
Crack cocaine.
All right. And that was just recent, or for years that has been something you struggle with?
For years, it's been something I struggle with, Your Honor.
Okay. If you end up going to Hope House, will that be the first time you've received formal treatment, or have you had treatment in the past?
That would be the first time I've been to an in-house program.
Got it. You've done some outpatient treatment?
Yes, sir.
Tell me about that.
I tried to complete the DRC program, MADRC program.
Mm-hmm.
But during that time I was shot, so I didn't complete it.
Oh.
So that was the only other program that I had.
Okay, you were doing MADRC, but then you were shot, and that meant you were out of commission for a while.
Yes, sir.
Okay, where were you shot? Like where on your body?
I was shot in the back 2 times in both of my hands.
Ouch. Okay. And what has your recovery been like?
It's been okay, but I still go to the hospital and receive pain medications.
Okay. All right.
One of my fingers can never, grow a nail. So.
Do you have any questions about anything we've discussed?
The program, I was asking the program person, like after I do the 120 days, do they still have a place where I can stay? And he told me yes, if I get a job, then I could pay for housing right there because I'm like technically homeless. So
that's correct. So we use Hope House often as part of drug court. If treatment doesn't go well in drug court, we escalate to residential treatment at Hope House. And if you do well in their program initially and then are working afterwards, they'll let you stay there. You just have to help defray the cost. I hope that's what works out for you. All right, Ms. Smith, your office filed a recidivist notice. Are you withdrawing that for purposes of the plea?
Yes, Your Honor.
I forgot one thing. I did want to ask for his fees to be waived for a while until he gets on his feet, and if you would be inclined to set up behavioral incentive date.
Okay. All right. Thanks for sharing that. I guess there's no restitution. Mr. Chapman didn't get his money back, but it's not the or.
We just haven't had good victim contact. We reached out to him multiple times and haven't heard anything back from him.
Okay. Got it. Mr. Kemp, I find there's a factual basis for your plea in that your plea is knowing and voluntary, meaning you've understood what we talked about and no one has forced you to enter this plea. Do you agree with that?
Yes, Your Honor.
All right, then I'll accept it. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Your Honor.
And Mr. Kemp, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, Your Honor. I got one more question.
Yes, sir.
Just to make some more point, right? It was the little program thing required that you come to the courtroom and give updates to the judge. I would like to do that.
Okay. I don't know that Hope House does that. Drug court does. You come every so often and we have a conversation about the things that are going well. And if things aren't going well, we talk about that also. But we could set up a date for you to come back, just sort of a check-in date to see how things are going at Hope House, if you think that would be helpful.
Yes, it would be.
Okay. I don't think I've ever had anyone ever ask for that. I think it's a great idea. I just don't typically impose it because it's a little tricky to make happen. But since you've asked, we'll try to make it happen. That's going to be a little bit on probation. We'll see what happens.
Thank you.
Okay. Anything else?
No, Your Honor.
Mr. Kemp, I am going to sentence you on count 1, which is the robbery count, to 7 years to serve 7 months with the balance on probation. And count 2 will be 7 months to serve. Those will run concurrently with each other. It will be a special condition of your probation that you enter into and complete the Hope House program. So you will stay at Hope House, and if it's 120 days, and sometimes it's longer if you slip up, but you need to graduate from that. If they kick you out or you quit, that's a violation of your probation, and that'll get you back in front of me, and that's not a happy check-in, but we'll work through it.
Yes, ma'am.
You'll also need to complete 60 hours of community service. That'll be within the first 9 months of probation. So you don't need to worry about it right away because you're at Hope House and you should be focused on recovery. But when you get out from Hope House, when you complete Hope House, you'll want to take care of the community service work. You should have no contact with Mr. Chapman, although I think he's a stranger to you. I'd stay away from the Greyhound bus station because that's just a source of woe for a lot of people. But I don't know if you use it because you actually take the bus, the Greyhound bus places.
Sometimes.
Where have you gone on a Greyhound bus?
I'm going to Cleveland, Ohio, Pennsylvania.
Okay. All right. Then just don't hang out there. Go there to take the bus and not to
Yes, ma'am.
rob a guy who's buying a hot dog.
Okay.
Did you mention GED, Ms. Rios? Was that part of it?
That was a part of one of the conditions.
Okay. I missed it. When you told us how old you were, Mr. Kemp, you also told us how far you went in school. How far did you go?
11th grade.
All right. Well, I'm going to make it a condition of your probation that you get your GED, and you need to be enrolled in a GED course within the first 6 months of your probation. So again, first few months you're at Hope House taking care of things, but eventually you need to get into that GED course as well. I will waive your probation supervision fees for the first 4 months. That's those 120 days when you're focused on recovery, but then you'll need to pay the supervision fees. And I'm not going to set a behavioral incentive date. You've got a pretty long period of probation from one of your other cases. This will run concurrently with that. But given your criminal history, I want to maintain the full length of probation. I hope you're turning a corner, but if you're not, and we have a situation where you're caught with a gun or doing something that you and I both know you shouldn't do, I think more time to work with for a revocation is better than less time. So I'm going to not set a behavioral incentive date. Ms. Rios, anything else on behalf of Mr. Kemp?
No, Your Honor. Thank you.
Ms. Smith?
No, Your Honor.
Mr. Kemp, any questions?
No, Your Honor. Thank you so much.
Oh, wait, I need to add one more thing. I'm going to ask that probation help with a check-in date of 2 months after release. So 2 months after you're released, probation should reach out to my staff and we'll figure out a court date to give you to come on in so we can talk about how things are going. And we'll decide after that 2-month check-in, do we need to do another one? Does that make sense? Or we're good to go?
Yes.
And we'll see how that works.
Thank you, Your Honor.
All right. I need you to stay put. Ms. Simpson's going to come to, I can turn this on. There's Ms. Yeah, right there. There's Ms. Simpson. She's going to ask you a little bit about, and talk to you a little bit about probation reporting.
Okay.
Good morning, Mr. Kemp.
Good morning.
So you're going to report to your probation officer, Officer Dowdy, within 48 hours of your release.
Okay.
I will pass on her information to your attorney. Is there a way that you can get a phone number, write down a phone number for her?
Yes. Yes.
Okay, let me know when you're ready.
The officer was writing it down now, ma'am.
Okay.
He said, hold on. Oh, I got it. Appreciate it. Yes, ma'am.
All right, so her name is Officer Dowdy. That's D as in dog,
Yes.
OWDY.
Yes, ma'am.
And her number is 770
Yes, ma'am.
842
Yes, ma'am.
7800.
It's 770-842-7800.
Yes.
Yes,
You
ma'am.
need to contact her within 48 hours of your release.
Okay.
Do you want the office number for Hope Hall? Because that's where he'll be living.
Yes, but also need the address, but which I think I have.
275, well, I'll forward you, unless you've got it. I can
Yeah,
just forward you the
it's
letter that Ms. Rios has.
Washington Street address.
Yeah,
I got it.
okay. I'll forward you this because it has the phone number too.
Thank you, Judge.
Okay. All right, Mr. Kemp, good luck.
Thank you so much.
All right, thank you, South Annex, for making him available.
Yes, sir. Have a blessing.
You too.
Is Adam coming back?
Is who coming back?
Unless they're back, Adam.
He has to be excused.
Oh, okay.
Oh, you work your case out?
No, so I guess I'll be.
Well, then he doesn't need to be here.
Well, I was gonna talk to him. I was good. He was gonna talk to the family. I was trying to get an update.
Okay. I'm sure you've got his email address or his phone number.
You know, everything.
All right, Mr. Richardson, are we good to go with Ms. Dawson?
Yeah, Judge, we speak to Smith.
Okay. And Ms. Smith, do you know what we're doing yet with Mr. Williams?
No, I just got an email from Ms. Wood, but I think it'll probably be a final plea hearing.
Okay.
Well, that concludes my business. I will see y'all Wednesday for trial.
Yes, I'll send out an email today with the list.
Okay.
I suspect at least one of your cases will be on it.
That's the only case I got.
Okay, it'll still be at least one. Ms. Wood, do you know what we're doing with Mr. Williams?
Emailing you back now. Emailing you back now.
Okay.
I'd hate for you guys to actually talk since you're standing next to each other instead of email back, but
Would make more sense, wouldn't it, Judge?
paper trail.
Exactly. So I'll have an announcement shortly, and then I do have Mr. Durante Jones here.
Okay, and what are we doing with Mr. Jones?
I'll be here.
Why don't we start that? Mr. Jones, come up to the podium, please.
Have a good one.
All right, Ms. Wood, you ready?
Yes, Judge.
Okay, we're gonna go on the record. Position 2 is 24 SC 002 181. Mr. Jones is here in court with Ms. Wood. Ms. Smith is the prosecutor. Ms. Wood, how are things going with discovery for you?
This is an older case that I had, so I have discovery on this case.
All right. Ms. Smith, what is the state's offer if Mr. Jones wanted to resolve his case today?
Yes, the state's current offer is 10 years probation, and I can break down each charge too if you would like.
No, so the global recommendation is 10 years probation.
Yes.
Okay.
There are a couple special conditions of probation too. Would you like those?
Well, if there are things like stay away and this and that, I don't need them. If it was onerous, I don't mean that in a critical way, but weekends in jail or you got to stay out of a certain part of Georgia, then you should share because that may be what the hiccup is in the case.
Okay.
Nothing like that. Okay. All right. Mr. Jones, the state's recommendation, if you were to enter a plea today, would be a sentence of 10 years probation. That's not what Ms. Wood would need to advocate for. It's what the state would advocate for. Today, if you entered a plea and I were to sentence you to more than what Ms. Wood asked for, I'm going to make a number up, but maybe she would say, I think it should be 5 years probation. If I were to do anything more than 5 years probation, you could withdraw your plea. You could say, no, thank you. I was willing to do 5 years, but not 8. After today, you can still enter a plea, but you're not going to be able to withdraw that plea if you don't like your sentence. Does that make sense?
Yes, sir.
Okay, that's the one thing that'll change after today. The state is going to recommend 10 years probation. Are you interested in entering a plea in your case today?
No, sir.
No? Okay. Your case will move to a trial calendar. I don't have that date yet. For some reason, you're not on the January 7th trial calendar. All the other cases are, but you're not. So it'll be sometime after January of next year when you'll come back in here for trial. You could still decide to enter a plea. You just don't get to withdraw the plea if you don't like your sentence. You can always have a trial. If a jury finds you guilty, you're stuck with whatever sentence I give you. If a jury finds you not guilty, then you move on with your life. Any questions about any of that?
Okay.
No? Okay. Ms. Wood, anything else on behalf of Mr. Jones?
No, Judge, thank you.
Ms. Smith?
No, Your Honor.
All right. Mr. Jones, let me check one thing in your case. So he had a bench warrant and it got set aside. Do you remember the circumstances of what was
Yes,
going
Judge,
on?
this is a case where the notice actually was going to the place where he was told to stay away from in the bond order.
Yes,
And it
okay.
has been corrected.
All right. In your bond, stay away from Haven Street, and that's where we were sending notices. Got it. You had a curfew. Were you wearing an ankle monitor?
Yes, I have.
You still have it on? Okay. Yikes. That's been a long time.
Yes.
Well, you and Ms. Wood should talk about that. And she'll give you her thoughts about whether it makes sense to try to switch that around. We won't deal with it today, but you can put that on her to-do list. Okay? Ms. Wood, anything else?
No, Judge, thank you.
All right. You are good to go, Mr. Jones. Oh, well, let me confirm, since we know we're not supposed to send things to Haven. And I have River Chase Drive. Okay, good. All right. So, do you need a chance to write an email back on Angela Williams?
I can multitask, Judge. I already sent one back.
Okay. I think he is the only one left for our final plea calendar. And then we've got Ms. Mann, maybe, and Ms. Dawson, maybe. Let me try to get him out of the break room, leave room. Hey, Mr. Williams, can you hear us?
Yes, Sean.
Okay. Well, what are we doing today, Ms. Wood, with Mr. Williams?
Just the final hearing.
Okay, well, let's get on the record for that. These are positions 3 and 4 on our final plea calendar. We have Mr. Williams out at the jail. Ms. Wood is here in court, along with Ms. Smith. Ms. Wood, do you have discovery in both the cases?
I do as of this morning.
Okay. Given the timing for both cases, I mean, they both came today?
Yes, Judge.
Okay. Given the timing of the arrival, does it make sense to keep Mr. Williams's final plea rights open?
Yes, Judge.
All right. Mr. Williams, here's what's going on. First, have you been at Rice Street for a while, or did you just get here from Department of Corrections?
Just got here from the Department of Correction.
All right. Did you finish up your sentence with them, or are we borrowing you from them?
Finish my sentence, sir. Your Honor.
Okay. Mr. Williams, Ms. Wood now has the discovery in your cases, so she is going to look through that, will undoubtedly want to talk with you about it, and then you and she can sort out which way to move forward. It may be that she has some motions she needs to file. It may be that she says, we need to try this case. It may be she says, we should try to work it out. I will see you at the latest on January 7th. That's when your 2 cases are on a trial calendar. I may see you before then if Ms. Wood files motions that are things that we need to talk about before the trial calendar. Okay? You have any questions about anything?
No, Your Honor.
Okay, Ms. Wood, anything else on behalf of Mr. Williams?
No, Your Honor.
Ms. Smith, anything else?
No, Your Honor.
All right, thank you, Mr. Williams, for your patience. You're good to go.
So I thought we were taking a plea today.
So what he's talking about would require the state to do something with one of the cases they're not willing to do. So, no.
Okay, let me pop you back on there. So, Mr. Williams, your lawyer proposed something to the prosecutor to make your case work in a certain way. And the prosecutor at this point is not inclined to do that. So in order to get the sentence, and I don't know the details, I don't want to get in the middle of it, but to get the sentence that Ms. Wood was advocating for, the state would need to agree to do something. And they're not obligated to agree. They know stuff about you and your case and your history, and they're taking one stance and your lawyer has a different stance, and those don't mesh. So it sounds like there's not going to be a plea today. Okay. Ms. Wood, you okay talking to Mr. Williams again?
Yes, sir.
All right. I'll put you in another breakout room, all right?
All right, thank you.
Let's see how we do this. So he's in there. And now we can move Ms. Wood. Ms. Smith,
Yes.
I'm curious. That's another case where there was no discovery. What do you think is going, or it was just delivered is a better way to put it. What do you think is going on?
I'm not too sure. I feel like, well, when the calendars come out, our legal assistants are supposed to send the discovery, so we're under the impression it's already sent. Because this case has already been through at least another calendar. It should have been sent by then. Once notified that it wasn't sent, I sent it to her, but
I know you
know
did.
that it wasn't sent to her.
Well, you are still new enough that you get to, I'm not saying this is what, you get to sort of like, it's not me, and it's true, it couldn't have been you, because discovery should have been sent months and months ago, whenever this case, right after it was on plea and arraignment. The scheduling order goes out, et cetera. But this 2 days in a row where you've discovered the discovery wasn't sent, is that a ADA didn't check up with legal assistant, or legal assistant misrepresented what happened, or what? I mean, I assume you're looking into how did this happen?
I think the legal assistant was supposed to send the discovery
Yeah,
after
just
the
didn't.
plea and arraignment calendar, but it was not sent.
Okay. Do you have a mechanism in place where you are checking to make sure you've had a few plea and arraignments? Are you planning on making sure that your legal assistant is taking care of discovery?
Yes, Sure. After the plea and arraignment calendars, I go through to see if discovery has been sent or not, and then send an email to the legal assistant asking them to either send it to them, or I've already sent it in for them to file the certificate of discovery.
Okay, but how are you keeping track? Let's say it's one where you ask the legal assistant, hey, send a McBurney discovery in State versus Jones. Legal assistant says, you bet, Ms. Smith. How are you making sure that that really happened?
Well, the process of that is just to check by, if I ask you at the beginning of the week, to check at the end of the week and to note it on my Excel sheet.
Okay, so you are then looking in to say, yep, there was a certificate of discovery, or you're able to tell
Right.
in evidence.com or something that it got sent?
Yes.
Okay, perfect. Mr. Richardson, are we ready now? Oh, you haven't had a chance to talk to Ms. Smith. Why don't you guys talk? Oh, right, sure. Yep, 404 564 4181. Uh-huh. I'm not listening, though. Hello again. Ms. Smith is chatting with Mr. Richardson right now.
Okay. Thank you, I appreciate that. It's very kind of you to say.
I saw that. That's so impressive.
It was funny going to this CCG conference, made me realize how many people on our report team are from New York.
Really?
I never really realized that. It wasn't out loud or being on home either.
Judge McBurney.
Attorney Wood.
Judge Schwall, he has a criminal case on right now? Or not? I just can't remember.
Yes.
I like drawing a blank. Okay.
Yes. Our family division judges are Eaton, Benton, Adams, and Ellerby.
Okay. Thank you.
You're not transferring, are you?
I might.
You have to at least give me the opportunity, or like the right of first refusal, like to match the offer. Yeah. Have an intervention. Why do you have a case in, Judge Schwal? Asia Rogers, what's going on?
Well, I didn't realize that, so, let me give you background. So,
I don't like this is how that looks.
well, so due to some minor technicalities, we can't petition for her, her relationship submitted, just do small technicality. So her officer advised for her to connect with an attorney to, handle a motion to terminate her probation.
Got it.
So, it's showing in the system that Judge Reader handled it.
Oh,
But when we looked at the actual sentence, I realized that it was a Judge Paul case that Judge Reader handled.
got it. Okay.
That's how it came out.
Okay.
And so I asked Ms. Wood if she would help out with her, and she's graciously did. But we thought the case was gonna be coming in front of you.
Because it looked like Reader, but it's Schwal. Okay. Mr. Richardson.
Yes, Judge. We're asking the court a bit of indulgence, and I'll explain why. When I first got this case with Ms. Dawson, if the court remember, my father has dementia. And I had to go to California, to Benicia, where he lives, for about a month to kind of take care of my sister, to get his housing and support situation straightened out. So I think we had an arraignment calendar. We might have had a final plea, but I don't honestly remember. This is the first time this case is ever on a trial calendar. This case is such that it's kind of a family and a big mess. You got one part of the family saying one thing, the other part of the family saying something else. The state's kind of stuck in a conundrum. The state has recommended, they're not in a position to reduce the case yet, but recommended that she interview for the diversion program. And it's important because she is a mother of 6. She works for MARTA. She was proud that she doesn't receive any assistance, not to shine on anybody who does, but she has a kid at KIPP Academy. She has another one that she works really hard. Her children are paramount importance to her. So what we'd ask the court to do, since it is the first time ever being on a trial calendar, to allow us an opportunity for her to interview with diversion, to see if they will accept her. The state is willing to allow her that opportunity. And if she's accepted, then I think that resolves the problem altogether. Because if she gets a conviction, she works in the maintenance division, but her objective ultimately is to drive the bus and the train. If she gets this felony,
That's not going to happen.
benefits are gone, all the stuff that she's worked for. And this is not to embarrass her alone, since she's a little girl. The father of her children aren't necessarily effectively in their children's lives. So she's the one shiny spot that provides support, pride, sustenance to the family. So we'd ask the court for the indulgence of one time continuance to see if she can qualify for diversion. If she can, she's more than willing to do it to preserve her job, et cetera.
Who is Starletha Thomas to Ms. Dawson?
It is her husband's brother's wife.
Ms. Dawson's married.
Yes.
Okay. And
Married to Jeremy Brooks, Jeremy Brooks.
so Mr. Brooks, Starletha Thomas, it's here, Ms. Dawson's husband's.
She's a sister-in-law of that.
Got it. Okay. Okay. So it's a relative of sorts.
Yeah. And then, Judge, if we were pre-trying the case, I would say that Jeremy left some of her personal belongings at his mom's house.
We don't need to pre-try it. I just was, so Starletha Thomas is someone known to your client and vice versa. Your client has 6 kids, and do they all stay with you, Ms. Dawson? Okay, and Mr. Brooks, is he the father of any of those kids?
He's the father of 5, but I've been with him since I had my oldest.
Okay, your oldest son has a different father.
Yes, sir.
Okay, the other 5 kids are all you and Mr. Brooks. Does he work?
Yes, sir.
What does he do?
He worked for the children.
Okay. Ms. Smith, I know the DA's adult diversion program is, maybe not be new to you because it could have been used in non-complex. Given the nature of the charges Ms. Dawson faces, is it kind of silly to think she even be accepted, or there's good reason to believe that she'd be accepted into the diversion program?
I think with the charges, it's kind of a toss-up when it comes to the diversion, because sometimes they will accept people with similar charges and sometimes they won't. I think with the position that the defense is in, with the state not being willing to reduce any charges at this point, is to just see if the diversion will accept her. I think because it's iffy on if she will be accepted or not, is why we're saying, okay, it's fine if she interviews with them. But if she's denied, then we go from there.
Okay, but it's not a lost cause doing it. There's a chance that she could be, there's a meaningful chance she could be accepted into the program.
Yes, Your Honor.
Okay. And you're comfortable with exploring that?
Yes, Your Honor.
Okay. And you initiate that, or Mr. Richardson initiates that? What I don't want to have happen is like, oh, I thought they were going to do it, and then it's a month from now and nothing's happened.
It's my understanding that Mr. Richardson would do it.
Do you know what to do?
I've done it once before, Judge, but I will,
I mean, if not, I could do it, but it's fine. Doesn't matter.
I just want to make sure that it happens. What I don't want to do is say, great, we're going to reconvene in X weeks, and the answer is no one applied her.
well, I'll certainly do whatever it takes, Judge.
I don't know that you can, though, not as in like, are you capable of? I just don't know. I was under the impression that it was an internal thing, that the ADA handling the case had to reach out to the diversion team to say, consider this one. I didn't know someone from the outside could knock and get in.
Yes, Your Honor. In some cases, or the defense attorneys are able to reach out to Mr. Pollard or diversion team to see if their client will be accepted into diversion. However, in this case, I don't have a problem doing the referral myself.
Okay. Well, I'm neutral as to who does it. I'm not neutral about does it get done, and it would need to get done next week. In terms of making the referral, they have to chew on it for a little while. Although it's supposed to, Mr. Pollard always says when I reach out, why haven't we heard about it? Like, oh, no, it only takes up to 72 hours. So in theory, we could know by the end of next week whether this is something that works out for Ms. Dawson, which would be great if it does. I'm not taking a position on good idea or bad idea. I just don't want us to go around and around. When Ms. Dawson has to come down here, that is, I'm sure, a childcare complication, and you're not at work. And eventually work's going to say, well, we don't want you here because you're always having to come to court. Okay. I'll figure out whether we roll this to the January trial calendar or if I put it on an inquiry calendar before then so that we can squeeze an update out of everyone as to where we are with it. Okay?
Okay.
Anything else, Ms. Smith?
No, Your Honor.
It's never easy with you, Mr. Richardson. Nope.
That's what I'm trying.
Yeah.
I heard yesterday, they had a big celebration in New York.
Yeah.
Remember, I had a really big night.
Yeah, I know. I hadn't heard about that thing. I'd be like, really? You didn't include me? But it was what it was. Jack Harvey was there, so that's the person who mattered. Yeah. All right. It may be that I reach out to the lawyers in a week saying, what did we learn or where are we? And Ms. Dawson, you'll get notice as to when you next need to come to court. If you're accepted into the diversion program, you're not going to need to come back to court for me to tell you that. You'll just need to start that program. All right? You guys are good to go.
Okay. Okay. All right. See you soon.
You bet. All right. So we've got a couple things left. I may need to go in a little bit. I'll let you know. But then, of course, I'll be back because we've got our 1 o'clock. We have Ms. Mann, but are you still working something out with Ms. Williams?
Yes.
Okay.
I think Miss Mann is now, is she on the Zoom? I think she just logged on.
Yes.
Okay. Yes, Miss Williams and I are still working.
Okay. Should we let Ms. Mann know that she can sign off and you'll text her?
Yes.
All right, Ms. Mann, can you hear me?
Yes,
Hey, look
I'm here.
at you. You're at work.
Yes, I'm working.
All right. It's a big looking building. And you've got your protective vest and everything. That's great.
Yeah, I'm ready.
In your same New Balance jacket. Ms. Wood will text you when, that's a lot of pipes, when you, should hop back on. She and the prosecutor need to talk more, and we don't want to keep you away from the job any more than necessary. So, just be checking your phone, and, she'll let you know when you should hop back on, okay?
Okay, well, I'm free for my break up until 1 o'clock, but if I have to log on anytime after that, I'm actually about to let my supervisor.
Okay. Well, we'll let you know. All the pipes went away and now we can't hear her anymore. All right. What about, Mr. Williams?
Judge, he would like to enter a plea. I think it's gonna need to be partially non-negotiated. The offer I received is a drug court offer, and so yeah, it's not negotiated.
Okay. But what's the non-negotiated? He doesn't want to do drug court?
Correct, and he's been in custody a year, so.
Okay.
Yeah.
All
I
right.
haven't applied him to it, so that obviously couldn't happen today.
Okay. Got it. So it's not that he has been admitted and doesn't want to go. It's that the state's thinking is that a reasonable program to address his situation is drug court, assuming he was admitted into it. Understood. Okay. Ms. Smith, you ready to go forward?
Yes.
Let's get. All right. Good. Miss Mann dropped off. She's suddenly outdoors. All right. I think this camera captures everyone. All right. Mr. Williams, can you hear? Oh, I got to unmute you. Unmute. All right. Mr. Williams, can you hear us?
Yes, sir.
Pardon me?
Yes, sir.
Okay, great. We're going to go on the record in your two cases. It's 24 SC 005863 and 25 SC 000299. Your lawyer, Ms. Wood, is here in court, as you know, because you've had to go into breakout rooms a couple of times. Ms. Smith is here. Mr. Williams, do you waive your right to be in court for your plea?
Yes, ma'am. Yes, sir. Yes, sir.
Okay. And do you waive your right to have Ms. Wood by your side?
Yes, sir.
Okay. If you need to speak with her privately, let me know and we'll get you in another one of those breakout rooms. Ms. Smith, when you're ready.
Yes, Your Honor, thank you. Mr. Williams, can you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Yes, sir.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
Yes.
What do you take that you did not get?
I take Tylenol.
Oh, you took Tylenol. Okay.
Take Tylenol, bro, this morning. I didn't put it on my nose. They came around. Well, I was going to give me Tylenols and.
Tell me what you took Tylenol for.
For my headaches, blood pressure medication. Blood pressure medication, they don't do headaches. So they don't do Tylenol.
All right, Mr. Williams, it's hard to hear you. That's not your fault. It's the microphone. So
they give me blood medicine, and they give me headaches. So they give me Tylenol.
Can you go over into booth 3?
His blood pressure medication gives him headaches, so he took Tylenol.
Okay, but the court reporter needs to hear him and not you.
Yeah, because I'm not understanding him.
No, me neither. And it's not him, it's the it's the microphone. So we're gonna try this one. Let me get that one up. Don't panic, we're not gonna be able to hear you for a minute. That's booth 3 open. All right, let's try that one. Mr. Williams, can you hear me?
Yes, Your Honor.
All right, that's better. So my understanding is that you take Tylenol to help with headaches you get because you have high blood pressure. Is that correct?
No, they give me blood medication. I mean, they give me high blood pressure medication. They give me headaches. So they gave me Tylenol along with it.
Okay, got it. You take it with it. When you take that medication, does it make you woozy or drowsy or confused?
Oh, I don't mean confused. They give me headaches. So they give me Tylenol to go with it for the headaches.
Okay, just headaches. Understood. Ms. Smith?
Yes. How old are you and how far have you gone in school?
37, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment or in both of these indictments?
Little, not enough time, but I had so much time.
Mr. Williams, it is important that we not rush things. If you don't feel like you've had enough time, you don't need to wait 6 weeks before you see me again. But if you need a meeting with your lawyer where she's out at the jail, we can make that happen.
I gotta understand what's going on, so I'm willing to go forward with it. I'm great.
All right, I need you to speak more slowly so we can hear you.
I said, I gotta understand what's going on, and I'm willing to go along.
Okay, you have an understanding of what's going on, and you are not asking for more time right now.
Yes, sir.
Okay, then we'll keep going.
Counsel, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Williams, do you remember being arrested for these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No, ma'am. No, no, ma'am.
Counsel, are you aware of any outstanding warrants?
No.
Mr. Williams, do you understand that you are entering a guilty plea for the following offenses in the indictment ending in 5863? Count one, possession of cocaine. Count two, willful obstruction of law enforcement officers. And for the indictment ending in 0299, count one, possession of firearm by a convicted felon.
Yes, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend to the court a sentence of 5 years probation?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing?
Yes, ma'am.
Are you currently on probation?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, The right to the presumption of innocence, which means that the state must prove you are guilty of each charge beyond a reasonable doubt. The right to testify on your own behalf or remain silent. The right to present other evidence of your own and call your own witnesses. And the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
And has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No, ma'am.
And as to indictment number 24SC005863, how do you plead to count 1, possession of cocaine, and count 2, willful obstruction of law enforcement officers?
Guilty, ma'am.
As to indictment number 25SC000299, how do you plead to count 1, possession of firearm by convicted felon?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
Yes, ma'am.
Do you also understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there is an error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal? This discretionary appeal procedure is outlined in OCGA 5635 and must be completed within 30 days of today.
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, if both of these cases would have gone to trial and in the indictment ending in 5863, the state would have been able to show that on March 17th, 2023, Officer J. Romero, that's Romero, along with Officer J. Douglas, were on mobile patrol in an area of 180 Ponce de Leon Avenue Northeast in Fulton County when they observed a Black male later identified as Mr. Williams standing in a location with another unknown white female, making a hand-to-hand narcotics transaction with what appears to be crack cocaine. While approaching Mr. Williams, he began to walk away from the officers. They gave him verbal commands to stop and for him to walk toward them, but he began to walk the other way opposite, which was north of Piedmont Avenue, into a parking lot. When the officers caught up with Mr. Williams, he was observed tossing a plastic baggie with a white substance over the fence that was in the parking lot. At that time, Mr. Williams was placed into custody and search incident to arrest. The officers found crack cocaine and some marijuana that was later tested at the GBI lab and confirmed to be 1.8 grams of crack cocaine. For the indictment, and those are the facts for the indictment ending in 5863. For the facts of the indictment ending in 0299, if this case would have gone to trial, the state would have been able to prove that on December 18th, 2024, Officer Gaines responded to, and Officer Hoffman was working a joint detail with Zone 1 and Zone 2. They ran plainclothes officers in that area at the location of 180 Ponce de Leon. The plainclothes officers advised that a Black male in all black was conducting multiple hand-to-hand transactions in the area listed above. At this time, while the plainclothes officers was observing Mr. Williams, the male in question attempted to sell marijuana to a plainclothes officer. At this time, several units responded to conduct the stop of the male. He was quickly detained, and while checking for weapons, the officers recovered a 9mm Smith & Wesson gun. The male was later identified as Mr. Angelo Williams. He was then placed under arrest and taken into custody. And this also occurred in Fulton County, Your Honor. Those are the facts of the case regarding the negotiated plea, the non-negotiated plea. The state is going to recommend a global offer of 5 years probation. To break that down with the sentence for the indictment ending in 5863, the state is recommending for count 1, 5 years probation, for count 2, 12 months probation to run concurrent to count 1. And for the indictment ending in 0299, the state is recommending a 5-year probation sentence for count 1. for a total of 5 years. For both of those indictments, term and concurrent, for a total of 5 years probation. And that's
Okay.
all from the state.
And what are the conditions of probation, if any?
The conditions of probation is for the defendant to complete an alcohol and drug evaluation, to forfeit the firearm that was taken when he was arrested, and for the defendant to enter in complete drug court upon acceptance.
All right. Got it. Thank you.
No problem.
Ms. Jackson,
Yes, Your Honor.
good morning. What can you share about Mr. Williams's criminal history?
There are 33 cycles. The last arrest was October the 29th, 2024 in Fulton County for a failure to appear. The underlying charge was not listed. He does appear to be on probation in Fulton County. The case number is 24 SC 001562 for possession of methamphetamine. That disposition date was November the 14th, 2024, and the term is for 2 years and 11 months. He does have prior felony convictions. One in 2017 for possession of a firearm by a convicted felon. One in 2011 for criminal attempt to commit a felony and aggravated assault and possession of a firearm during commission of a felony. And there's an additional one in 2011 for the sale of cocaine and hijacking a motor vehicle and criminal damage to property in the second degree and obstructing an officer and fleeing or attempting to elude an officer. Nothing in addition, Your Honor.
Thank you so much. Ms. Wood, share with me what you want. I know discovery is fresh for you. You said something that piqued my interest, which was he's been in for a year. And I did notice that soon after his arrest in the newer indictment, so December of last year, he got shipped off to the Department of Corrections. So tell me what's been going on there, along with anything else.
Yes, Judge, thank you. So I just sent the email. He's actually, once you add up all of the dates, he's been in right at 1 year since this situation.
Because I got 88 days, but that's based on the time he was in for the December arrest. And then, like I said, he got shipped off. He'll get credit for that time as well. Just it's GDC credit.
Yeah, so he actually, and I just sent an email with the DOC little document. So he was there for 8 months. He got there. So he was here and then he was shipped there in March and he was brought back to Fulton last week.
But he was there for what?
The methamphetamine case, I believe. The probation that he's on.
He got revoked.
Yes.
He got revoked. Okay.
So that's why he was there. Judge, as you know, like I said, I don't have discovery, so I noticed he was shaking his head. I can't really rebut whatever he was disagreeing with on the facts because I don't have the evidence, or I haven't been able to look at the evidence yet.
Well, and it was so we're clear, it was the older of the cases. And to me, that meant that's 2.5 years ago. And the officer said he saw a hand to hand from a distance. The more concerning one is the more recent one. And he sold to a cop and he had a gun on him. He was not shaking his head while that was being described. So I'm focused on that one.
Thank you. So I had spoken with Mr. Williams earlier this year when he was with the Department of Corrections. We zoomed him in for an arraignment court date. And then I spoke with him earlier this week on a phone call. I didn't realize that he was here in Fulton. So he has indicated to me that he is ready to move forward. And he does have support here. His fiance is here, present in court, Judge. So we're just asking for a sentence of 5 to serve 1 year credit for the time that he's done.
Okay. And any conditions of probation?
Drug and alcohol evaluation treatment if needed.
All right. Mr. Williams, anything you want to add to what Ms. Wood said or any questions about anything we've discussed?
And the time of with the it ain't travel. No.
Anyone want to translate that?
I don't know what that was.
I said, due to the fact this ain't trial, no one,
Nothing you want to add?
and what should I add?
Nothing. You don't have to add anything. I just, sometimes a defendant wants to say, hey, I miss my kid, or I want drug treatment, or the prosecutor is a bad person, or whatever. You don't need to say anything at all. I need to give you that opportunity, and you can say, I'm good, and you're saying you're good.
Yes, Your Honor.
Okay. Well, I find there's a factual basis for both of your pleas, and that your pleas are knowing and voluntary, meaning that you've understood what we talked about, and that no one is forcing you to enter these pleas. So you are comfortable going forward. But I want to confirm that, because you wanted to move fast. Your lawyer was saying, hey, it would be good to look at discovery. But Mr. Williams, you want to go forward with these pleas. Is that correct?
Yes, Your Honor. My best, I think for my best sake, my best, due to the fact of the, what the offer was, the plea was, yes,
Yep.
Your Honor.
Okay, you think the offer of probation is in your interest?
Yes, Your Honor.
Okay, all right, I follow that. Ms. Smith, your office filed a recidivist notice in at least one of the cases. Are you withdrawing that or those for purposes of the plea?
Yes, Your Honor.
Ms. Wood, can someone in my office sign your name to the two indictments?
Yes, Judge.
I think one is an accusation, but either way. And Ms. Smith, can we sign for you?
Yes, Your Honor.
And Mr. Williams, can we electronically sign your name to the two documents indicating your plea?
Yes, Your Honor.
Okay, we'll do that. I think the sentencing range in the case ending in 863 for count one is actually 1 to 3. So I don't think I could get up to 5. I can in the other case, so I'm not worried about it.
For the count one is, if it's between 1 to, if it's more than 1 gram but less than 4, the sentencing range was 1 to 8.
Oh, I didn't know there was a weight.
Yes.
Okay, and that weight was more than a gram.
Yes.
Okay.
A little bit over 1 gram, but it was more than.
Got it. Okay, so 1 to 8. Got it. Thank you. So in the case ending in 863, I'm sentencing you to 5 years to serve 1 year with a balance on probation. Count 2, I'm sentencing you to 12 months. That'll run concurrently to serve with count 1. And the sentence in that case will run concurrently with the sentence in your other case ending in 299. And in that case, your sentence is 5 years to serve 1 year with the balance on probation. You will forfeit the firearm that was seized, and you will need to complete the Metro Atlanta Day Reporting Center, which is a restoration and treatment and job readiness program through probation. You'll need to attend the classes as they tell you to attend those classes. Will you all be living in the Fulton County area? Yep, that'll make it easy. And that will be the special condition beyond forfeiting the gun in both your cases. Ms. Wood, anything else in connection with Mr. Williams?
Yes, Judge. For the final disposition, are we good if I sent all of the dates with the breakdown to Ms. Nelson? I just don't want to run into the issue that we just had with my other case. So are we good if we just put all of those dates on there?
I haven't looked at your email, but if your email is what you say it is, and I have no reason to doubt it, we'll put all those dates in there. Ms. Nelson doesn't mind putting the dates in as long as they're documented.
Okay.
And what we've run into trouble, frankly, is not with you, but a prominent private attorney who says, and then this kind of, and says some days, but there's no paperwork for those days. And so then we don't say those days. We just say, hey, you should get credit for time. And then the county doesn't see those days because they were in other jurisdictions.
Got it. I sent all the booking numbers and then also the DOC PDF.
Okay. All right. Ms. Smith, anything else in connection with Mr. Williams's two cases?
No, Your Honor.
All right. Do you need to give Mr. Williams some reporting instructions or connecting with an officer he already has, or?
Yes.
All right. Mr. Williams, please listen up. Ms. Simpson is coming to a camera near you. All right.
Good morning, Mr. Williams. So, you're going to report to the Atlanta Probation Office. Do you remember where that is?
Yes, ma'am.
So you need to report there within 48 hours of your release. Your officer is Officer Lewis. I will pass along your officer's information to your attorney, so that she can get it to you, but you need to report to that Atlanta office within 48 hours of your release.
Yes, ma'am.
Okay? Thank you.
You're welcome.
How long have you known Mr. Williams?
10 years,
10 years. How's this going to work out?
it's gonna work out, I'm gonna make sure it works out. And then every step of the way.
All right, well, we need your help.
What happened before we do it, moving forward.
All right, we need your help. He is a hard-headed guy who, we'll see what happens. But just so you understand, if Mr. Williams and I are together again in 6 months, because, yeah, he's got dope or a gun, then you're gonna need to find a different man for the next few years, okay?
Yes, sir.
All right.
Question, quick question, if he's in Fulton County Jail right now, so he can go ahead and be processed out?
Yeah, I mean, I don't know that he's gonna be released today. No one should get their hopes up about that. They've got to mess with the paperwork and confirm that it adds up to a year. If it's a little shy of a year, he's got a few more days to spend. If it's more than a year, then they'll get him out.
You had mentioned he did the 88 days previously before he went down the road, he didn't get credit for that. So he did the 88
I
days.
don't suspend penalty.
Yeah, he did time on Rice Street, and then he did a whole year.
Got it. We've got all that. I can only see the Rice Street time, and I'm talking about that. But Ms. Wood has been working hard on Mr. Williams's behalf to get the Department of Corrections time. So no one's going to shortchange him. It's just we need to get the documents. And they all relate to this. It was him being a knucklehead selling to a cop that got him that year. He has no one to blame. He seems angry, but he should look in the mirror and say, I'm going to do better by my girlfriend or fiance or whatever. But that's on him. We'll see what happens. All right. Thank you.
Okay, thank you.
Mr. Williams, anything else?
No, Your Honor.
All right. You can go. So I think we're done. Why are you still here, Ms. Dawson?
That's one, I'm so it's customers working on.
Oh, that's nice of Ms. Nelson. Mr. Richardson, I think we're good till 1. That's when we have, can I have the case number?
Yeah.
And it may help Ms. Jackson to get that as well.
One moment. Okay, so it's 23 SC 191907.
All right. So Ms. Jackson, we are back in about an hour and we are taking a plea. It's a gentleman in federal custody. And his name, you may already have all this stuff. His name is Antonio Milner.
Yes, sir, I have it.
You got it. All right. I figured Ms. Nelson took care of you. But we'll do that at 1 o'clock.
Yes.
Oh, and then you're going to figure out Ms. Mann over
Yeah.
the lunch break? Okay. All right. I'll be back in about an hour.
Thank you.
Thank you. There's been a Tamika Stone on the call the whole time.
The man case.
Okay.
Yes.
All right. Can you all on Zoom hear me? Yes, excellent. We had a little hiccup with the feds. They use WebEx, which is great, but there was no host to let us in. So we were all staring at each other in the lobby, except the lobby was pitch black, so we couldn't see each other. So we were not able to go forward with the case. Ms. Willingham has come up with a solution to it so that we don't have to get back on WebEx with the feds and be left in their electronic lobby. But that leaves us then with Ms. Mann's case from our trial calendar, which is position 12. And I see Ms. Williams on the call. So we've got the state side of the case, and there's Ms. Wood, and there's Ms. Mann. Great.
Judge, Ms. Wood's gonna have to sign off and sign back on. She's having some audio problems.
Okay. We will wait for her.
Hello?
Hello.
Okay.
I'm sorry we didn't get to do this, Ms. Mann, during your break, but that's just not how things played out here. But I think we'll be able to go forward in a minute. Ms. Wood had to sign off, and she's signing back on right now.
Okay.
Oh, and then she dumped it again. She shouldn't have left. Ms. Wood, is your equipment working now?
Judge, I'm zooming in from my phone. I think when I was on the WebEx, I don't know what happened. But my computer's not working, but I'm on my phone and I think I have good enough service. So
Great. Then we will get everyone we need. Ms. Mann, are you able to get to a place where you can stand still? She did better than standing still. She froze. Ms. Wood, unrelated case, McCrary, we just got the forensic report back.
yes,
And, pardon me?
I see that, Judge. Yes.
Yeah, I'm kind of surprised given what's been going on at the jail, but okay.
Same.
Yeah, Colonel Edwards would love it if we fast track that one. I don't know anything about the facts of the case, but he's having struggles out there.
It is a shame it is not a Williams or Willingham production. I will say that.
All right, well, maybe we can get some supervisory assistance. Hey, Ms. Mann, are you able to stay right where you are for a little bit?
Yes, I got tired of walking, so I'm just gonna sit here.
Okay. Can you hear us?
Yes, I can hear you.
Okay, we can see you. Ms. Wood, are we able to go forward now?
Judge, so I believe so, but I will full candor because I was trying to do the Milner situation as well as the Mann situation. Miss Mann and I have been going back and forth just up until this last minute or so. So I have a feeling there might be a couple of things that she needs to stop and we get clarification on. So if we could just take this nice and slow.
Okay, we'll certainly do that. Do you want to hop off and have a phone call with her first?
I think we're good, Miss Mann. Do you have any questions about what we were texting about?
No.
Okay, well then we'll go forward. We'll go forward, but Ms. Mann, if at any point you want to talk to Ms. Wood about things that come up, you'll let me know?
Yes.
Okay, all right. Then let's get on the record. This is 25 SC 000-934-01. It's a superseding indictment, State versus Mann. Ms. Mann is appearing virtually, as is her lawyer, as is the prosecutor. Ms. Mann, do you waive your right to be in court and agree to appear virtually?
Yes.
All right. And you also have a right to have Ms. Wood right there next to you so you guys could huddle up, but that's not how this one's working. Are you okay with that?
Yes.
All right. But you'll let me know if you want to talk with Ms. Wood.
Yes, I will.
Okay. Sounds good. When you're ready, Ms. Williams.
Thank you, Judge. Ms. Mann, good afternoon.
Hi, how are you?
Please raise your right hand. Thank you. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, ma'am. You may lower your hand. Could you please say and spell for the record your full legal name?
Danikia Mann, DONIAMAN.
Okay. Did it break up a little bit for anybody else? You broke up just a little bit, Ms. Mann.
It did, but I think the spelling of the name, we've got that in the record, is MANN. If when Ms. Mann is answering some of the critical questions like, how are you pleading? We'll make sure that it's clear, and if not, she can repeat herself.
Excellent. Thank you, Judge. Ms. Mann, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
27.
What is the highest level of education that you have completed?
12th grade.
Did you graduate from high school or you made it to 12th grade?
I made it to 12th grade, but I didn't graduate.
Okay.
Understood. Are you therefore able to read, write, and understand the English language?
Yes.
Ms. Wood, on behalf of your client, do you waive formal reading of the indictment?
So waived.
Ms. Mann, do you understand that you are charged with 3 counts of cruelty to children in the first, which carries a sentence range of 5 years to 20 years?
Yes.
Okay. Ms. Mann, have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes.
Have you had enough time to speak with your lawyer, Ms. Wood? Apologies. To speak with your lawyer, Ms. Wood, about all the facts and circumstances. Hold on.
Yes. Yes, I have.
Let me start over again. Have you had enough time to speak with your lawyer, Ms. Wood, about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case right now with Ms. Wood?
No.
Are you satisfied with Ms. Wood's services?
I am.
Ms. Wood, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to her name?
We do.
Ms. Mann, have you been arrested on these charges?
Yes.
Ms. Wood, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
I do not.
Ms. Mann, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
And just once again, each count carries a sentence range of 5 years to 20 years.
Is there a question about that, or you're just informing her?
I was just informing her again, Your Honor.
Okay.
Ma'am, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
Your Honor and Ms. Mann, as to the actual terms of the offer, Ms. Wood, I'm going to read from the email that I sent you.
Okay.
And of course, stop me if we need to discuss anything. Your Honor, the offer is for each count would be 10 years of probation, those to run concurrent, for a total of 10 years probation, with the following special conditions: no illegal drugs, no alcohol, and prescription drugs only as prescribed. Defendant must submit herself to random drug and alcohol screens. Within 90 days of entering the plea on the record, defendant must enroll in one of the following courses and thereafter attend sessions to complete the course. Ms. Mann could choose from moral recognition therapy or anger management. Now, we did discuss, Your Honor, that Ms. Mann has taken a number of courses as part of a defects matter. If Ms. Mann can produce for the satisfaction of Department of Community Supervision that she has already taken one or both of those courses, then the state is fine with that requirement being satisfied. The next special condition is that Ms. Mann have no further violent contact with victim Michaela, McKayla, Mann, MANN. That visitation with Michaela's paternal grandparents should be governed by Department of Family and Children's Services, family court, or any good faith agreement expressed today between defendant and the paternal grandparents. Ms. Tamika Stone is on, who is Michaela's paternal grandmother. Defendant must maintain at least 20 hours per week of employment or full-time enrollment as a student at a college, university, GED program, apprenticeship, or trade school. We did have some discussion regarding community service. At this point, the recommendation, well, my offer was that Ms. Mann complete 30 hours of community service. And of course, if deemed appropriate by Department of Community Supervision, the state is fine with that community service being completed at any school or schools attended by Ms. Mann's children. The state does recognize that as part of an earlier Department of Family and Children's Services matter, Ms. Mann did complete the following services. Ms. Mann completed domestic violence assessment and therapy. She completed individual and family therapy. She completed a psychological evaluation. She completed parenting classes, and she also did submit herself to some drug screenings. The state does not object to a 3-year bid date if defendant has fully complied with Department of Community Supervision and has not failed any drug and alcohol screens within that time period. Additionally, and finally, the state does not object to a limited time waiver of defendant's supervision fees, that time to be at the court's discretion. Ms. Wood, was that about right?
Yes, that is exactly as the email was said. And there's some things I'll clarify for the record when it's my turn to speak.
Okay, excellent.
Thank you.
Thank you. Ms. Mann, having heard the terms of the recommendation, do you wish to proceed with this plea?
I just feel like it's only one person. I've majority of the classes, and on top of that, I've technically been on probation with trial for a year. I showed proof of drug tests and I passed it. I'm like, why I have everything over?
So hold on, Ms. Mann, you got to stop. You're breaking up and our court reporter, Ms. Rivers, can't take down what you were saying. So I don't know if it's just bad reception where you are, but I was getting the sense that you were saying, hey, I already took a lot of these classes. Why should I take them again? Which is a fair point. But I want to make sure that we all hear what you have to say and that it goes in the record. So you want to try again?
Yes. Also, on top of that, I've technically been on probation for a year with pretrial, and the school been like having 20 hours of school or work. When this case started, I was actually enrolled in school for my GP. I can't even think right. I'm so frustrated.
The GED.
Yes, I was
Yeah.
in for that, and I was getting ready to start my classes for OBGYN, but I had got unenrolled due to me missing so much from me having to deal with this case and go back and forth to courthouse and stuff. And I am working, but I just feel like it's just a lot on me.
Well, we don't want to put.
I deal with this past year, so.
Okay, well, let's move forward with this a little bit more, and then you can hear what I've got to say about what I think the reasonable conditions are, and then you and Ms. Wood can talk to me about them, okay?
Okay.
All right.
So Ms. Mann, for right now, I'm going to go ahead and proceed with the plea as the judge has instructed. Ms. Mann, I would like to make you aware that this plea may be used to enhance sentencing on other convictions in the state of Georgia, as well as any other state and the federal courts. Do you understand that?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a U.S. citizen?
Yes.
Additionally, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Ms. Mann, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or no contest to, or ever been convicted of a felony in the state of Georgia or any other state?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney, Ms. Wood, explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge in this indictment?
Yes.
Do you still wish to proceed with first offender treatment?
Yes, I do.
I'm now going to go over the constitutional rights that you are waiving by entering a plea of guilty. Do you understand that you have the right to plead not guilty?
Yes, I do.
Do you understand that if you plead not guilty or remain silent, this matter could proceed to jury trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury?
Yes.
Do you understand that you are giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that you are giving up the right to confront witnesses against you?
Yes.
Do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case? Do you understand that you are giving up the right to the presumption of innocence?
Yes.
Do you understand that you are giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that you are giving up the right to subpoena witnesses and to compel the production of evidence? Do you understand that you are giving up the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes.
And finally, do you understand that you are giving up the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
I don't understand it.
What do you not understand?
Are you saying like I waive my rights because
Your Honor,
Yes, ma'am.
at some point we had discussed whether this would be an offered plea for her. I know she witnessed an offered plea yesterday in court. And so I think that might be perhaps what the holdup is for her now. Is that correct, Ms. Mann?
Yes.
Are you still wanting to plead guilty because it's in your best interest? You would be admitting that the state may have enough evidence to gain a conviction at trial, but you're pleading guilty because it's in your best interest?
Yes.
Okay.
Understood. I will then proceed with the offered questions. Ms. Mann, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Are you asking the court to accept your plea as guilty under offer?
Yes.
As to indictment number 25 SC 000934-01, how do you plead to count 1, cruelty to children in the first degree?
Guilty with offer.
And is your plea the same for count 2?
Yes.
And are you entering the same plea for count 3?
Yes.
Is this guilty under offered plea to all 3 counts, entered freely and voluntarily with full knowledge of the charges against you?
Yes.
Ma'am, you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in the Official Code of Georgia Annotated, Section 5-6-35. Do you understand that?
Yes,
Do you understand that the appeal that we have just discussed must be filed by your attorney unless you are representing yourself?
yes,
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
yes.
Thank you, Ms. Mann. That concludes all the questions and information that I have for you. I will now turn to providing the court with a factual basis for the plea. Your Honor, on Saturday, August the 17th, 2024, officers from the South Fulton Police Department reported to Wellstar Medical Center in reference to potential child abuse. The officer that responded spoke with a nurse regarding a 4-year-old patient whose name was Michaela, again, Mckayla, Mann, Mann. X-rays and examinations had shown that Michaela had a fractured leg, and she also had multiple older wounds throughout and on her body. With the child, Michaela, at the hospital was her grandmother, Tamika Stone. The matter went through a DFACS investigation. Numerous people did review the X-rays. Michaela did go through also a forensic interview, which was extremely compelling. And Your Honor, of course, Ms. Stone is here to speak at the appropriate time if you would allow her to do so. The state and Ms. Wood came to this agreement because asking Michaela to testify in this matter would have been extremely difficult for her. The state does believe that the medical evidence was extremely compelling. We believe that the forensic interview of Michaela was extremely compelling. However, Michaela also very clearly loves her mother. And she has been placed back in the custody of Ms. Mann. And so at this point, after speaking with Ms. Stone, who of course was the reporting party, I think everyone has come to the conclusion that this is a reasonable resolution.
Or maybe the least bad resolution.
Correct, Your Honor. That's probably a better phrasing.
Okay. I would like to hear from Ms. Stone about any concerns she has about the reunification that occurred. Ms. Stone, are you able to join us?
Yes.
Good afternoon. I appreciate you being on. I know you've been on for a while. Hopefully you've been able to do other things, but now's the time. So you are Michaela's grandmother?
Yes, sir.
And Michaela was put into your care and custody after this situation occurred?
Yes, sir.
Okay, well, thank you for being there for Michaela. And now Michaela is back with her mother.
Correct.
Your Honor, I can't
Okay,
hear.
we back. We was out for a second. I couldn't hear anything that you said. It did something different. So, okay. Could you repeat what you were, or was I saying before we got? Because I don't even. All I know is the screen went to.
Yes. For a little while, the audio coming from the courtroom went out, Your Honor.
All right, we should be back. Can you hear us again?
Yes.
Okay, frustratingly, this, today has gone longer than it was supposed to, and I have a 2 o'clock with a different session, and it grabbed this microphone in here. So Ms. Stone, I'm sorry for the disconnect. That was on us over here. You are Michaela's father's mother.
Correct.
Got it. Is Michaela's father active in her life? Not so much.
He's deceased.
Oh, I'm sorry to hear that. I was unaware. I'm sorry. But you are, which is good. And I'd like to know how it has been since Michaela is back with her mother.
I haven't been able to see her, except for a few minutes when I got her school clothes and I met her mom. But other than that, I haven't been able to see or talk to her. Me and Michaela, we have a very close bond.
Are you still there?
Okay, I'm back. It cut out again. But me and Michaela has always had a very close bond from the time she was born. I cut an umbilical cord. She was with me from day one up until I started back working. Then this incident occurred. And it was pretty bad. Do I think that her mother is a bad person? No, I don't. I know she's angry with me, but at the same time, when we're not held accountable for certain things and don't know it's wrong, then we'll continue those same actions. I've always been there for Michaela as well as her mother. I just want what's best for Michaela as well as her mother. If her mother is in good position mentally, spiritually, she'll be a good mother for Michaela and the rest of her daughters. She has 3 beautiful daughters. And I know it can be frustrating as a single parent, but I've always been there for my granddaughter. I think it's very important that we continue the relationship that we have and the bond that we have where I'm able to spend time with Michaela. That's important. As well as I feel like being with her mother is important. She loves her mom. Just because her mom made a mistake or an action doesn't mean that she doesn't love Michaela, because I truly believe that she do. Sometimes when we go through things and get frustrated, we tend to take them out in the wrong place. And I think maybe that was something that's going on. Maybe she still grieving from my son, and that's another factor. But the same way it's important for Michaela to be in her life, I feel it's important for Michaela to be in our life as well, her dad's side. At the end of the day, I just want what's best for Michaela. I'm still here for her mom, but Michaela is suffering the most right now. She has, this is affecting her mentally, and emotionally. It's been hard on everybody. I didn't want her mom to go to jail because that's not going to help anybody. She still has 3 babies that love her.
Is Michaela the oldest or the youngest? What are the ages of her kids?
He's the middle. Michaela is the middle. They're 6. My oldest is 6. Michaela is 5, and I have a 2-year-old, and they're all girls.
Okay.
Yeah.
So,
Can I say something?
you can. It's not your turn yet, but you'll get a chance. And I'm glad you're in your car because it's easier to hear you now. Right now, it's Ms. Stone's turn to chat with me. Ms. Stone, I appreciate your willingness to be there for Michaela. Were you also then the primary caregiver for the 2 other girls after this happened, or just Michaela?
Just Michaela.
Okay. And is Michaela the only one who was your son's daughter, or are all three of them?
Just Michaela.
Okay, got it. Do you know if the other two girls were taken from Ms. Mann during this period after this incident?
They weren't.
Okay, so they stayed with her, Michaela stayed with you, and now DFACS, which is closer to this than I am by far, has concluded that Michaela can be back with her mother.
Correct.
And since then, you have not had an ability, you haven't been able to or allowed to see Michaela, other than this something about bringing some school clothes.
That's all. Yeah.
Okay. All right. Well, again, thank you for being there for Michaela in the time when everyone involved felt that it was appropriate for her to be out of that household for a while things were investigated. Grandparents have to pitch in later in life than they expect, and it was great that you were there.
You know, I want to say this also. What I've always given Daniki a credit for, like I said, my granddaughter spent a lot of time with me, been with me months and months on, actually almost like 3 years straight. And what I had so much respect for Danikia for, even though we would have our arguments and whatever, but when she knew she needed help or she was in a situation and she wanted Michaela to be safe, she would place Michaela with me and knew that Michaela was safe. We have a love-hate relationship, but we don't hate each other. This situation right here was very serious. I can understand her being angry with me, but if it wasn't something that was serious, then we wouldn't even be here right now. I was not trying to hurt her, but I couldn't allow her to hurt Michaela.
Right. The medical evidence is pretty scary here. So I understand what you're saying.
Yeah.
Okay. All right. Well, thank you, Ms. Stone. You're welcome to stay on for the rest of this proceeding. But I appreciate you sharing what you've been through and how you were there to help. It helps flesh out the picture for me.
Okay. Thank you.
All right. You bet. Ms. Williams, anything else?
No, Your Honor. Thank you so much for allowing Ms. Stone to speak. She was able to give you more context of the facts than I really could have. And I'm also very thankful to Ms. Wood and to Ms. Mann for being willing to just be here and try to make this happen. Thank you.
Okay. Ms. Jackson, criminal history information for Ms. Mann, please.
Yes, Your Honor. There are 6 cycles. The last arrest was July the 9th, 2025 in East Point, Georgia for a driving while license suspended or revoked. There was no disposition for that arrest, and there were no convictions listed. I did see an old hold out of Calhoun, Georgia for a failure to appear. The underlying charge was not listed. The date on that warrant was November the 23rd, 2021. Nothing in addition.
Thank you, ma'am, and thank you for your help yesterday and today. You have a great weekend.
Thank you, you as well.
Ms. Wood?
Hi, Judge. Thank you for your patience today with this case. So this has been a long and winding journey for Miss Mann and myself. Miss ADA Clark had the case first. Part of the delay in getting to the point of taking a plea was that the state had a different offer before Miss Williams came on. It involved a program called Families First. And so part of our back and forth that Miss Mann already completed a series of classes, as you heard. She worked through an open case with DFAC from August of last year until February of this year. And so she felt that an additional program was not necessary, especially since DFAC cleared her, has custody of all 3 of her beautiful daughters. Judge, she's working. She's hoping to complete her classes. She really just wants to move forward. We had a long conversation this morning. She understands that it is going to be important Michaela to have a relationship with Ms. Stone.
I need you to hold on for 1 sec. She just dropped off, so I don't want you to go further. Hopefully she will plug back in.
Also, is the echo on my end or in the courtroom?
Is who what?
I hear an echo. I can't tell if it's me or if it's just the courtroom.
It's you, Ms. Wood.
Yeah, your connection is subpar right now, so I think it's something you're hearing. You are just coming through enough that I think Ms. Rivers is able to handle it, but there's occasional chop.
Okay, I'm like booted off of the Wi-Fi, so I apologize.
Okay. Hold on, Ms. Mann is back. I want to make sure she can hear us. Hey, Ms. Mann, can you hear us?
Hey, yes, I can hear you guys.
Okay. We paused once I saw you drop off, so Ms. Wood was saying some nice things about you, and she's going to pick back up.
Okay.
And again, I apologize for the audio. She understands, Judge, time heals all wounds. She is understanding that it's important for Michaela to have a relationship with Miss Stone and that side of the family. And so she understands that that is something that she hopes to work towards. She's just not there yet. There are some big feelings about this case, as you know. We are asking for first offender treatment, Judge. I think she's a good candidate for it. I'm also asking for the behavioral incentive date. I'm asking for probation fees to be waived for a period of time. And also, I know the state, I understand why there's a random drug screening, but I don't think alcohol was an issue here, and alcohol is legal. So I would ask that that not be imposed. But yeah, that's all I have for now. And I think Ms. Mann will probably want to share something with the court.
Okay, and I will hear from her in just a moment. I want to work through a few of the conditions. So I'm inclined to impose the drug and alcohol abuse evaluation, and then any treatment if necessary. I'm curious if, insofar as you're able to share this, Ms. Wood, if in your discussions with Ms. Mann, it came to light that what happened in August of last year between Ms. Mann and her daughter was linked at all to Ms. Mann drinking or being in a bad state of mind because of things she had consumed, as opposed to it just was too much. 3 kids, life is complicated. She lost the father of one of her kids, et cetera.
That was never, it's my understanding that was never an issue. I know there's mention in the discovery of someone thinking that there was a substance abuse issue, but I've not seen any record of that. She actually turned over a stack of clean drug screens to me. But I will let her expound upon that if she sees fit, Judge.
Okay. In terms of coursework, it sounds like things she's already been doing through DFACS would cover the equivalent of a family violence intervention program, anger management, et cetera. Getting a GED, I think, is a great idea. She got so close by getting to 12th grade. Are there objections to that?
No, Judge.
Okay. Obviously, no violent contact with her daughter. I didn't follow, I thought I followed when Ms. Williams was explaining what the conditions were. I thought it was before the facts of the case. And so I thought Michaela was in Ms. Stone's custody. And so one of the conditions of the sentence was, yes, Ms. Mann, you can visit your daughter, but only by coordinating with Ms. Stone. But that's clearly not the case. Ms. Stone is very anxious and desirous of having time with her granddaughter, but that would be, as you said, negotiations she has, conversations she has with your client going forward. What was the piece, what was the condition going to be about the paternal grandparents?
Your Honor, we recognize that, there couldn't be any way to include that in the deal. We were just hoping to include language that might encourage everyone to work toward that.
Got it. Okay, then I think I follow the conditions. Thank you for clarifying that. Ms. Mann, is there more you want to say about this situation? And I know you're going to tell me some about you. I am also interested in Michaela and why you think whatever happened in August of last year will never, ever happen again. I know it's been difficult for you. In some ways, this isn't about you. It's about Michaela. And so that's my number one concern is how do we make sure this doesn't happen again?
To answer your question, what happened was not because I was angry about her father passing or because I was angry with her grandmother, because they have nothing to do with anything. I had asked Michaela several times. For one, it was a school night. And Michaela, I know she liked to eat her junk food and she liked to ramble or whatever the case may be. But I had told her over 3 times, I'm like, Kayla, lay down, go to sleep. It's after 12 o'clock. I'm telling her this. I get up and I go in the kitchen. It's food all over the floor. She done been all in the refrigerator and I spanked her. It wasn't because I was mad or frustrated. It was because I asked you more than one time to stay out of the refrigerator. You're supposed to be asleep. It's a school night. On top of everything else, I'm not saying that her grandmother is a bad person, but what I feel like was took out of proportion of me spanking her. I would never do anything to fracture a bone or hurt her in that type of way. But as her mother, I do feel like I have that right to spank my kids, discipline them. Kids are going to be kids. I do get that, but they also have to be respectful and they have to have some type of discipline. Just because I'm a single mother doesn't mean anything. Even kids who have a mother and father at home, parents still get frustrated. Kids are going to be kids, but this was not out of an act of anger or grieving. I don't smoke. I don't do any kind of drugs. I may drink wine here and there, but I'm not a bad person. I'm not a bad mom. I just made a mistake, and that was spanking my child. But I do feel like I can't discipline them. You know what I mean? I got 3 girls. I'm trying to get my life together so that they don't see what I'm going through. I want to go back to school. This is not my career that I want. I want to be an OBGYN, but I feel like I'm dealing with so much that's holding me back from doing it. And this is just too much. I can't handle all of this. Like the probation, I'm okay with getting my GED because I started doing it. But as far as anything else with law enforcement, I just want to move forward with my life. Like, I don't want that on my back because I'm not that person.
Judge McBurney.
And that's all I have to say.
Okay.
As far as her having a relationship with her brother, we can get to that, but I'm not ready for that right now. But I feel like that is something that will come about in due time. But I just need to heal and just get myself together first mentally before I could do that again.
Okay. I appreciate you sharing that. Ms. Wood.
Judge, and I apologize. I forgot to share. There was at some point in the defects investigation, there was mention of jumping on the bed and getting injured that way. So I do just want to throw that out there. I know some of the discovery that I received from the state had some older scarring that was obviously not from jumping on the bed, but the fracture in question, there is an argument to be made that that was actually from jumping on the bed. Know whether that's from negligence or what, but I did just want to add that. I meant to tell you that previously.
Okay. Thank you. All right. Well, Ms. Mann, do you have any questions about any of the things that we have been discussing during this long conversation?
No, I don't have any questions.
Okay. Well, Ms. Mann, I find that there's a factual basis, that there is evidence for me to accept your plea. I understand, now I'm not remembering, this is an offered plea, yes?
Yes.
Yes, that's what I thought. And so that's you telling me that you think it's in your best interest to work the case out this way, but you disagree with some of the things that the prosecutor said happened in this case. And that's okay. You can disagree. I will tell you that I find that if the state could prove up the things that they described, a jury could find you guilty of cruelty to children in the first degree. I think the medical records would be pretty complicated for you to work through, and it would be your lawyer having to work through it. And it sounds like Michaela, some of the things that she told the neutral interviewer, who isn't for you or against you, just trying to figure out what happened, some of those things might have been pretty tricky to work with at a trial. So I'll accept your plea. I also find that your plea is knowing and voluntary. First offender is something you qualify for, Ms. Mann, because you haven't really been in trouble a whole lot. What's the status of your driver's license now, since you're sitting in a car?
I'm paying on my ticket. So basically, the hole that's in Calhoun, they don't want me, but what the judge told me was he reduced my ticket. When I was arrested in July, I got out and I had my granddad drive me to the judge, and he reduced my ticket from $1,200 to $600 because I had to explain to him, like, I'm a single mother and I have my own place. So I just started back working. I've been here 30 days, so I'm kind of playing catch up with my bills and trying to put money to the side for the ticket, which I only have to pay $600. And he's gonna remove the warrant and unsuspend my license, and then I just have to pay to get them reinstated. So I'm trying to get that done before January. Actually, that's my goal, to have all of that paid and my license reinstated before then.
So if your license is not reinstated, how do you get around?
My sister or my grandmother or my mom, whenever they're off, or sometimes I may have to Uber or Lyft.
Okay. Tell me what you're sitting in right now.
I'm in my coworker's car.
Okay, got it. She just gave you a space where you could be quiet and have a conversation.
Yep.
Okay. All right. First offender means that this wouldn't be a conviction. You'd be under sentence for a while, but if you successfully completed your sentence, when you're done with that, you could get it removed from your record. And if you're trying to go back to school or apply for other jobs, you would not need to check the box that says you are a convicted felon. That's a real good thing. The downside, Ms. Mann, of first offender is that if in 6 months or a year or whatever, you have another episode where you get too forceful with one of your kids, it doesn't need to be Michaela, it could be any one of them, or something else happens in your life where you get arrested, that arrest and the facts relating to the arrest could cause your first offender status to go away. And based on how you're charged, it's up to 60 years of exposure that you have. And let me just translate that into something concrete. If you and I and Ms. Wood are having a conversation in a year because another one of your kids has a broken bone and it looks like you had something to do with it, if the state presents me, and they don't have to present much, some evidence, not only do you have your new case, but I would be revoking a big chunk of those 60 years, having decided that it is not safe for you and your kids to be together. And I'd be worried about the parts we didn't catch. And it may be that never happens, but I need to make sure you understand the risk of first offender, that if you mess up while you are under this sentence, it can have some pretty serious consequences. Do you feel like you understand that?
Yes, I do.
Okay. Understanding that, do you want to be sentenced as a first offender?
Yes.
Okay. So what I'm going to do, Ms. Mann, is as to count 1, sentence you to 5 years. Count 2 is 5 years consecutive, and count 3 is 5 years consecutive to that. So it's a total of 15 years. The first 5 years are probated. The next 10 years are suspended for now. If those first 5 years go well, then you don't need to worry about having probation in your life or in your kid's life. But if there are issues during those first 5 years, then I have the ability to turn the suspended sentence into a sentence where you are under supervision. I understand your point. You want people out of your life so you can move forward and take care of your business. But when you were not having people in your life and taking care of your business, this situation with Michaela happened. And so for a few years, you're going to have a probation officer and you're going to need to comply with some conditions of probation. If that goes smoothly and you're working and your kids are doing fine, then we ought to get out of your way and you'll be in a good space. It will be a special condition of your probation on count 1 that you get your GED, and you'll need to re-enroll into a GED course within 6 months of the start of your probation. So you don't need to do it right away. You told me you're catching up on things, but within the first 6 months of probation, you'll need to show your officer proof of enrollment that you're taking classes. Within the first 3 months of your probation, you'll need to sit for a drug and alcohol abuse evaluation. And if everything is as you described, and occasionally you just drink some wine, that's going to be easy. And no one's going to say you need to do anything. But if it seems different to the medical professional who talks to you, and that person recommends treatment, you'll need to follow that treatment. I'm not recommending any other classes. DFACS has had you take a whole bunch of classes that hopefully are helping you deal with the frustration of having kids in a different way. Kids will be kids. They do need to respect authority. You as a parent are certainly entitled to discipline your kids, but not in a way that results in the kinds of things that were in those medical records. No violent contact with any of your kids, but it would be a crime anyway to have too much violent contact with any of them. I am not setting a behavioral incentive date because you've got an incentive to have probation work out well. If it does, then those remaining 2 5-year periods will stay suspended, which means no supervision, nothing. You're doing your thing and folks are out of your business. Ms. Williams, anything else in connection with the conditions of Ms. Mann's sentence?
No, Your Honor, I believe that what you've stated encapsulated what our desire was, which was just basically to look out for the best interest of Michaela in this situation.
Sure, and that's my primary goal as well. I believe it's yours, Ms. Mann's. I know it's Ms. Stone's, and so I can't make you do anything on that front, but I would urge you, as soon as you feel you are comfortable doing it, to re-engage with Ms. Stone, so she can be present in Michaela's life. And frankly, you get free childcare that way. And so once you are feeling more comfortable with your emotions about what went down and what was said about you, et cetera, I hope that you invite Ms. Stone back into your life and more importantly, into Michaela's life. I think that'll be healthy for Michaela and it will take some work off your shoulders. You are carrying a whole lot and getting help is not a bad thing. Ms. Wood, anything else on behalf of Ms. Mann?
No, Judge, thank you.
Ms. Mann, I need to make sure you understood what I was talking about. Do you have questions about anything that I mentioned?
No.
You sure?
Yes.
Okay. In court right now is Ms. Simpson. She's with probation. She is going to come up to the podium. It's the only camera that's on right now and give you some reporting instructions for probation. Probably the second most important thing said in our conversation beyond Ms. Stone letting everyone know that she is there for Michaela is you making sure you report to probation. So please engage with Ms. Simpson right now.
Miss Mann, what is your zip code?
30344.
Okay, so your reporting date is going to be November the 24th. And you're going to report to the Atlanta Probation Office at 276 Memorial Drive. That's here in Atlanta. And you need to report there at 9 a.m.
Okay, I work Friday through Monday, so could I do anything between Tuesday and Thursday? Or is it mandatory that I report that Monday for the first day? Because I don't think I could call off. I'm still in my 90-day period. I just made 30 days on Monday. So I'm not sure if I'll be able to call off.
What day are you requesting?
Tuesday, Wednesday, Thursday.
Yeah, Tuesday, Wednesday, Thursday.
You will need to report Thursday on the 20th.
Okay.
And that day you will need to be there at 8 a.m.
Okay.
I'll send all this to you, Ms. Mann.
Okay.
All right, but so I'm clear, we switched it from Monday, and thank you, Ms. Simpson, for doing that, because this is a precious job right now. And so it'll be Thursday, a week from
November the 20th.
20th. All right, so a week from yesterday.
Yes, Judge.
At whatever time you said. Same location on
Yes,
Memorial
same
Drive.
location at 8 a.m.
Okay. Ms. Mann, do not miss that meeting, okay?
Okay.
All right. Last chance. Any questions?
Okay, I do have one question. Okay, so you said once I for the probation it's 5 years and 10 suspended years. So I have to do the drug evaluation, and if they don't see fit for anything, then I'm fine.
Right, and correct. And then you're going to enroll in the GED course.
Okay.
And all that's going to be, you don't have to memorize what I just said. Ms. Wood will get you your final disposition. That's the paperwork that lists all the requirements. And you'll have that so you can keep track. And your probation officer is going to have that. And that person's going to talk to you about the things you need to do. Okay?
Okay. Thank you.
All right. Good luck. And thank you, Ms. Stone, for wanting to continue to be present in Michaela's life.
Ms. Mann, can you make sure Ms. Wood has your updated address, phone number, and a good email address?
Yes.
Thank you.
All right, Ms. Mann, good luck with things. You do juggle a lot. I understand that. That's not an excuse to get too rough with your kids, but I understand that it can feel like a lot, especially when you are driving that bus all by yourself.
Right. Thank you.
All right, bye-bye.
Bye-bye.
Judge, wait, may I be excused?
Yes, you and Ms. Williams. I will see you all on Wednesday morning. We'll figure out what we're doing with our various cases. The magic email went out, so you can see sort of the order in which things are going.
Thank you.
All right, thanks, guys. Thank you, Ms. Rivers.
Okay, Judge, have a good week.